And we're also given this to mention a matter not only law. This matter has been mentioned at least 50 times by now before different benches for the last 2 years. On the previous occasion, about 3 weeks ago, for the fifth time I mentioned this matter to Lordship, your Lordship directed the matter to be listed. But somehow the registry has a peculiar habit of uploading cases. As a result, while the school has to get double promotion, should I get demoted to Lordship? Today's item 57, next time I see 71. But the registry top notes never heard. I've practiced extensively before I do.
Registry, don't blame the registry like that.
No, but how else can this happen?
It happens. No. Some old matter, let us say, it is listed and it goes to the top of that matter. So obviously it will come down. It's not that they are deliberately
But the
doing.
weekly list doesn't grow.
No. It's not that aji 51 achi, kali 75 re rahigala ta mane
registry. Thereafter disappears from the list. That's been given somewhere.
Please.
The date of Lordship list, but
Please give it.
But fixed date, my lord, and a top of the list.
Pardon mention, my lord. Petition is languishing in jail custody more than 11 years.
Give it.
My lord, it is on behalf of the government for vacation of the state.
Yeah.
Can you be pardoned? The applicant is in custody since more than 17 years. The matter was to be listed to the not listed.
Supplemental list, item number 1.
Please, your lordship. This is an appeal against conviction, and the appellant has been convicted. So, lordship will kindly have the sentencing portion, which is at page 56 of your lordship's brief. I've been convicted for life under section 302 of the Indian Penal Code. And the
Many delay, how much delay?
delay of
85 days.
90 days. 90 days is higher numbers to answer is an application for combination of delay. The stamp report has pointed out that there is delay of 90 days in filing the criminal appeal. The hearing the land counsel for the parties and consider the government's taken in the interim application, and since the appellant has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned. Admit for the trial court report, interim application for bail and stay relation of time to be considered for receipt of the trial court report. Reposition copies be supplied in the meantime.
Item 2.
My lord. My lord, I have filed the copy of the order of OSS Additional Commissioner of Revenue, Court number 4, Bhubaneswar yesterday. I have also filed a copy, served the copy on the executive copy also.
No, you sought for time on the to file an application for amendment, incorporating all those things. So have you filed that?
I need some time to file the
that's all right.
amendment itself.
And ATMT body del habani taku IA karibe taku amendment karibe tapre taku incorporate karikini
IA kali file karichi.
O karijan. What is the number?
6108. In fact, that second round of litigation. Second round after another. IA 6108 of 2025.
25. This is an application for amendment.
Yes.
The Learning Council, Mr. Sahoo, submitted that yesterday. He has filed an interim application for amendment and of the writ petition, and the same has been registered as the IA number 6108 of 2025. Copy has been served.
Sir, just a copy. They will serve in court.
A copy of the interim application is served on the Learning Council for the state. Matter be listed next week. They give the 16/4/2025 with IA number 6108 of 25.
Amendment after that.
Yes, sir. once it is allowed, though the likely you are to incorporate it and file a consolidated petition.
Yes,
That's afterwards. Let it come first for us.
Item 3.
Mr. Seth,
Yes, now, last date your lordship directed for instruction regarding disposal of the. As per
no,
the-
we called for waiver the status of the representation filed by you before the opposite party number 3.
My lord, it
Opposite-
LA 28.
Opposite party number 3 means you Kalu Maji, special land acquisition officer ଆପଣ ଦେଇଛନ୍ତି ଆସିଲା କି instruction
Even though notice was issued from the Advocate General Office,
କେବେ ପଠେଇଛନ୍ତି
hello?
କେବେ ପଠେଇଛନ୍ତି
It was last issued on 11/9/2024.
ନାଇଁ ମ ଅର୍ଡରଟା ପୁରା ହେଲା ଏବେ 10/3/2025 ରେ ଅର୍ଡର ହେଲା
In fact,
କଣ୍ଟେମ୍ପ ପିଟିସନ ରେ ଅର୍ଡର ହେଲା ତାଙ୍କୁ ରିଟ୍ ପିଟିସନ ଯୋଉ ଡିସ୍ପୋଜ ଅଫ ହେଇଥିଲା
the status as per the
status of
23/4/2024 order.
right 10/3/25 order and you have to just obtain instruction from that man
Give me some time, I will call back.
opposite party number 3
Again, the collector.
ବହୁତ ପିଟିସନ ତାଙ୍କ ନାଁରେ ପଡୁଛି ତା ସାଙ୍ଗେ ଟିକେ କଥା ହୁଅ ଏଇ ରିପ୍ରେଜେଣ୍ଟେସନ ସବୁବେଳେ ସେଇ ଡିସ୍ପୋଜ ଅଫ କରୁଛନ୍ତି ଲୋଅର ଇନ୍ଦ୍ରା ଇରିଗେସନ ପ୍ରୋଜେକ୍ଟ
Or in the irrigation.
ପକେଇକି ରଖୁଛନ୍ତି ଯାହା କରିବ ପଟ ସେପଟ କରି ତାଙ୍କୁ ଜଣେଇଦବ
ଆଜ୍ଞା।
ବର୍ଷ ଧରିକି ପକେଇକି କଣ ରଖିବ ରିପ୍ରେଜେଣ୍ଟେସନ ସେମାନେ ଆସିବେ କଣ୍ଟେମ୍ପ ଫାଇଲ କରିବେ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ହଁ the Learning Council for the
15 days time. That
state 2 weeks time to obtain instruction about the status of representation filed by the petitioner before the opposite party number 3 could matter on 6th of May 25. 2 सप्ताह ହେଇଗଲା ଆପଣ ବେଶୀ ଦିଆ
again.
ହଁ
3-4
3 and 4 ଆଚ୍ଛା 4 ରେ ମଧ୍ୟ ସେଇଆ
Again, same. This is order dated 23/4, that is 24/4.
ଆଚ୍ଛା ସେଠି ଅର୍ଡରଟା ଦେଖିକି ଲେଖିବେ
Same party.
ଅଲଗା ଅଲଗା ଡେଟରେ ବୋଧେ ଅର୍ଡର ହେଇଛି
Again,
ଓକେ ତ କିନ୍ତୁ ଦିଟା ଆସିବ 6/4/2025 ହେଲା
Item 5.
Please, Your Lordship. 16 more some to time because we have written letter to the opposite partner 3 regarding that status of the payment deposited on that. I am appealing for NHAI also. We have written letter, we have not obtained any instruction. Madam, kindly keep.
yes you are appearing for NHAI in opposite party number
4. We have written letter to the
yes just a minute
Right.
project director National Highway Authority of India right
Right.
okay 28/2025 ର ଅର୍ଡର ଅନୁଯାୟୀ ଆପଣଙ୍କୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବାକୁ ପଡିବ 28/2025 ରେ କଣ ହେଇଥିଲା ଅର୍ଡର ଅଛି
that will be direction.
Land Council for the National shall obtain instruction whether any money has been deposited with the opposite party number 2 land acquisition officer come competent authority National Highways Authority of Orissa Chhatrapur Ganjam for the order passed by the district judge Ganjam Brahmpur in SPJC number 184 why disbursement money has not been made to the petitioner as per the said order also पास ही केबेटू हेलानी 28 ମାନେ 3 ମାସ ହବାକୁ ହବ
My lord, actually, Mr. Yuki Mahanti, thereafter this matter has been transferred to me. Thereafter, I wrote letter to the, I informed the concerned officer.
so you have filed your appearance memo
Yes, I filed my Pakam. My name is also
Santosh Kumar Dwivedi
My-
London Council appearing for the opposite party number 4 so now like the opposite party number 1, the project director National Highway Authority of India submits that as per order dated 28/1/2025 he has sought for instruction and some more time may be granted to him of this matter. 6 तारीख आसु 6/5 अपन you are getting more than 2 weeks time, right?
I've already written to them. So that
6/4/2025.
written letter to on March.
ठीक है ସେଗୁଡ଼ା ଦେଖିବା ଦରକାର ନା you are granting time.
Item 6.
6th of May, my lord.
6th
Yes.
of May 2025.
March. Okay.
Pray for
Which time, my lord? You some medical.
is a fresh matter.
Fresh matter.
अच्छा like mention is what is your good name? S.R. Acharya and counsel appearing for Mr. Gopabandhu Mishra 6 for adjournment. कितने दिन दरकार?
2 weeks.
2 weeks. 6 तारीख नहीं आसुन 6/5/2025.
Item 7.
May be clear also. My lord, I'm an educational institution. My lord, annexure 1 is my application, different before is possible. Annexure 2 is my application for application release. Annexure 3 is the encroachment case. My DC land is usually for a playground.
No, disposal of
Annexure 1.
EC number. No,
Case 73 of 2001
case पड़िछि pending अछि कोठे EC number 73
of 2011.
कोठी अछि सेटा
Tahsildar Bones.
Encroachment case.
encroachment case
That is
23 of 2011 तहसीलदार पाखरे अछि
आगे
ए पर्यंत किछि ये ही नहीं
रिप्रेजेंटेशन देछि
रिप्रेजेंटेशन छाड़
बहुत दिया है
तो आणंतु तार स्टेटस आणंतु
आगे।
पेंडिंग अछि बोली केबे तार किछि प्रोसीड करे दैछंदी
नहीं किछ सो देछि तपस
हां
आगे नहीं एटा इसी केस टाइप ये जो इसी केस स्टेटस शो दे दैछि आगे ये जो लीज अप्लाई कर तब से
ना लीज ना इसी केस अगेंस्ट व्हिच यू हैव कम
इसी केसटा आपण जो डिस्पोजल होउनी ताकू क्विक डिस्पोजल पई आपनकर प्रेयर हेछि
मो प्रेयर लीज अप्लाई कर इन्वेस्टमेंट करले आ लीज अप्लाई कर ये हमको पिला मन
प्लीज सी योर प्रेयर लैंड एंड काउंसिल प्लीज सी योर प्रेयर
read it
we do and after hearing to direct the opposite party for disposal ECS notes pending in the court of particular one in which application for lease was filed as per annexure 2 and the reparation as per 1 as per possibility.
So you are praying for a disposal of this EC सेई आपण कहउछन कोन आपण डिस्पोजल चाहू आपण गोटे एप्लीकेशन देइछन लीज पई
दरखास्त भी देइछि
there is a land encroached by you basing on which encroachment case has been initiated against you against that notice you have claimed that the land be leased out in your favor so
separate thing
you have to apply for lease that is different EC you have to fight
lease case ta would separate application debe that is to be considered separately au EC case re kon dei dichandi se application encroachment case रे आपण जदी कोनसी गवर्नमेंट लैंड को चाहउचंती जे लीज रे दी नबा पई तार प्रोसीड्यूर अछि ओजीएलएस एक्ट रो जे
दर ओजीएलएस लख देइ से एप्लीकेशन
नहीं से एप्लीकेशन काई एप्लीकेशन एटा कोन इसी नंबर लिखाई लीज रे लीज केस गोटे लीज केस हुए
लीज केस ता
answer 2 is encroachment case
फिर पूछे
This is under separate
एप्लीकेशन सेटलमेंट ऑफ लैंड लिखचंदी सेड कोन इसी लिखाई जी उता ऊपर पेश
annexure 1 ता डिस्पोजल पे जाऊ जे डीसी जहां
so according to you the land which is under your encroachment be leased out to you how can it be
annexure 1 ता डिफरेंशियल डिस्पोजल जाऊ से जहां कर हां डिस्पोजल करू यदि हमर योग्यता धन पाई
annexure 2 you have given before whom
तहसीलदार
केबे देइछन
तो दे 3 2011 encroachment case order पर
Annexure 3 टा देखले जाना पड़िबो page 50. That is the order sheet of the EC.
encroachment case.
application विषय କିଛି ଲେଖା ହେଇଛି
ଖେଳ ପଡିଆ
obviously ଯଦି लीज ଇଏ ହବା କଥା ସେଟା ଗୋଟେ लीज मिसकेस हुए लीज मिसकेस ହେଇ ତାର procedure follow हुए ସେ
ये OLR गला को इटा OPL है
हां ଏଟା
माने बहुत सारा
representation one टा
ଏଟା ଗୋଟେ confusing clear type ର
OPL ଅଛି OPL ରେ notice against ରେ ଆପଣ ଆସୁଛନ୍ତି there is provision under the OPL Act you are coming in the
it is opposite.
ଏଇଟାକୁ ଯଦି confine କରିବେ prayer to କେବଳ ବର୍ତ୍ତମାନ annexure 2
at best we can
Take into consideration annexure 3.
annexure 2 ଟାକୁ consider କରିବେ ବୋଲି କହୁଛନ୍ତି
ଆଜ୍ଞା
we cannot
ये ଦେଇଛନ୍ତି ଆମେ ତାକୁ ସେଇଟା
that is not under EC case sir that is a different case
that is you are not saying that whether on the basis of this application any leach case has been instituted
ମାନେ ସେଇଟା
confused no
ଆପ୍ଲାଏ କରୁଛୁ କରୁନାହାନ୍ତି କିଛି
ଆପଣ ପରା ତା ଉପରେ ନମ୍ବର ଦେଇଛନ୍ତି EC case ର ଆମକୁ ଲାଗୁଛି no 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 not in that way ଆପଣ EC case ରେ କେମିତି ଗୋଟେ application ଦେଇଦେଲେ settlement of land ର
ନା ନା ଏଇଟା ସେପାରେଟ ଦିଆ ହେଇଛି ଏଇଟା ମୁଁ ଲେଖିଛି ସେ କଲା ବେଳେ
ଲେଖିଛନ୍ତି କଣ ମନ ଲେଖିଦେଲେ
ଏଇ କେସରେ ମୁଁ ଲେଖିଲା ବେଳେ ଲେଖିଦେଇଛି
where have you taken averment that you have filed an application let us see in your writ petition when you filed
page 4
how देखो
on 31st February 2002 11 to Festival of 2011 instead by Tahsil Bhubaneswar as the institution you give the issue to land as a playground and water card that would consolidate on 28 2011 direction given to village general and reserved on the application to
you filed the EC case you file a separate application that will be registered as lease miss case ତାଙ୍କର ଯାହା procedure follow up होगे ସେ କଣ ଦେବେ ନ ଦେବେ that's a different matter ଏ writ petition ରେ ସେ direction ଦେଇ ହବନି because it's a confusing one
representation consideration
the representation ରେ ଆପଣ concession କରିକି ସେଟା lease ବି decide हो ବୋଲି କହିବେ how can we grant that
then you କହିବେ ଯେ you have got an order from the High Court so look this writ petition has been filed by the petitioner Times Scholars Gurukula to its secretary Dr. Sarada Prasad Misra for a direction to the opposite parties for disposal of encroachment case number 73 of 2011 pending in the court of Tahsildar Bhubaneswar in which application for lease was as per annexure 2 and representation as per annexure 1 however during course of argument the land and counsel for the petitioner confined his prayer for a direction to the Tahsildar Bhubaneswar from opposite party number 3 for early disposal of the lease application under annexure 2. On perusal of the same, it appears that said application has been filed in the EC case. The land counsel for the petitioner seeks permission to withdraw this writ petition to file a separate application for settlement of land in accordance with law. Accordingly, the writ petition is disposed of as withdrawn. Yes.
Item 8.
Item number 8, yes.
Six five.
6/5.
Covered matter we
We do not know the. He has sought for instruction and let the
NHAI
instruction
authority
come.
has sought for
Yeah.
information to comply this.
Yes, item number 8.
Item number 8. Complaints for adjournment.
What is your good name?
Parmishta Ponda.
Na likhi diyo unko. You have got no power in this case. You are making a submission on behalf of Mr. Lakshmi Narayan Patel, so and so and counsel appearing for Mr. Lakshmi Narayan Patel, advocate, 6 for an adjournment. कितने समय दरकार?
1 week.
1 week.
Item 9.
Direction, the award amount is less than the market value of the government market valuation
Enhancement.
on the annexure 4 man.
So enhancement ପାଇଁ ଯିବେ appropriate option ଦେବେ.
Yes. And in the similar case, my lord pass.
No, ये representation कौन हो? Representation can do.
On the 64 is a
Yes,
separate
data.
application before the
64 application देवे. और
Yes.
तादर से अभी delay जी.
Yes, yes.
June.
That application withdraw what may cancel.
Deleted.
Then ଆପଣ ଏକ withdraw କରିକିନି proper application ଦବାକୁ
Yes.
ଚାହୁଁଛନ୍ତି ଆଉ
ଅସୁବିଧା କଣ?
କଣ ଅସୁବିଧା କଣ ହେଲା?
So withdraw what
ନାଇଁ ଉଧାର ହେଇକି ଆସିବ ନା.
You can maintain this as well as an order.
Withdraw this.
How can it be?
Because
Because an alternative forum is available, it cannot be maintained. Rather, it should have been dismissed. We are not putting the word dismiss, we are putting the word dispose.
Yes, sir.
କଣ ଅସୁବିଧା ଅଛି? Application ଟା ଯୋଉ format ରେ ଦବା କଥା ଦେଇନାହାନ୍ତି.
Exactly.
Representation ଦେଇଛନ୍ତି ଆପଣ zone officer ରେ. 64 କହୁଛି କାହା ପାଖରେ ଦବା ପାଇଁ?
Authority.
64 କାହା ପାଖରେ କହୁଛି? କଲେକ୍ଟରଙ୍କ ପାଖରେ ଦବା, କଲେକ୍ଟର ରେଫର କରିବେ ଅଥରିଟି, ଅଥରିଟି ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍.
Time frame. Yes, sir.
ଆଉ ଇଏ ଜୋନ୍ ଅଫିସର କଣ କରିବ?
Applicant can also file summary before the authority.
ଦେବେ ଯଦି ମାସେ ଭିତରେ ସେ ନ କରିବ ତାପରେ ଡାଇରେକ୍ଟ ଅଥରିଟି କୁ ଆପ୍ରୋଚ କରିବେ, ଅଥରିଟି ଡାଇରେକ୍ସନ ଦବ କଲେକ୍ଟର କୁ ସେ ରେଫର କରିବା ପାଇଁ.
Item 18 also.
Just
Them.
same order କୋଉଥିରେ ହବ?
Item 18.
ଆଚ୍ଛା, disposal clause 18. Yes.
Item 10.
Annexure 1. He challenged before your lawsuit. A revision was initiated under section 38B after 5 decades against the petitioners and others.
Which order you are challenging?
Lord, may kindly see Annexure 1.
Annexure 1 of who order ta?
Page
3/10/2024.
Milord. 3/10/2024.
कोई पेज रखी सेटा बात 3/2/2024.
Please 30.
30 हाँ इटा 3 अच्छा okay please place it
Milord. On 3/10/2024, the member board of revenue passed this order when I have challenged the maintainability of the proceeding and after 5 decades. So previously a notice was served upon me.
No, the order in the last portion of the order dated 3/10/2024 indicates that it is posted to 7/11/24 for hearing on merits from both the sides.
Here, my application for maintainability and limitation has been rejected. Lords may kindly see that page in view sub-para, Milord, from top, Milord. In view of the above, the application, Milord, page 43 or 60.
In view of the
In view of the above, second sub-para. Lords, got it?
Yes, yes.
The application written shows filed by OP number 35 on the issue of delay and maintainability of the present division case is thus disposed of as rejected. I have challenged that.
कौन फाइन रिजेक्ट कला ग्राउंड देती हो
Milord, my submission before Lordship, Milord, it was taken up behind my back without providing an opportunity of hearing and rejected. Lordship may kindly see page 37 first. Milord, the previous history is that the proceeding under section 38B was initiated and notice was served upon me. Challenging that notice, I have approached your Lordship in a read petition. Read petition was disposed of. Lordship may kindly talk.
What is the date chart? Let us see.
Lordship may kindly turn to 9/10/2015. In 38B proceeding, the matter was admitted and notice was served below.
बाकी जोना पुगनी कौन आपनो रेडी कंफ्यूजिंग होची जो डेट चैप्टर देइछन
Milord,
कोडी आपन देइछन को डेट रे आपन नोटिस पाइले
Milord,
आपन कोडा चैलेंजिंग द ऑर्डर पास्ड बाय द opposite party number 3.
Milord.
The opposite party number 3 माने without sworn so heard the matter and passed the order.
Milord.
And who proceeding there?
38B proceeding. If proceeding under section 38B was initiated.
On it as a kemt initiated la mane ke
at the instance of the government.
That's a so moto se mane
so moto proceeding was taken by the government, by the board of revenue, moved by the collector.
No, कौन तारा ये थिला कौन? What was the prayer or the proceeding was initiated for what? What purpose?
That proceeding I have given, Milord. They have said that the settlement made in favor of my vendor in the year 1971, which was also confirmed by the commission or settlement in 77.
एटा कौन लिखते हैं ऊपर 18/8/71 और पास्ट इन हुई है केस नंबर कौन देता
है सही गोटा हैला सेटलमेंट हैला बाय द
सेगुडा लिखी बना और टिके
that order I have given.
No, you prepare a date chart. We'll take up this matter next week. Just सम्यकटा देवे ना खाली order passed in हुई है केस नंबर एट लिख पर था दे इन and the land was settled. तो ई टाइप रो टिके लिखले सुविधा हो जिनको हां अब जे आरपी केस रे की चैलेंज तब की कला
नो वेंडर
हां लिखी हुई चैलेंज एंड इट वाज कंफर्म्ड instead of
since I have given the order, Milord,
we'll take up this matter on 16th. Prepare a chart, proper date chart. Mr. Vivekanand Bhuya, Land Counsel, appearing for the petitioner. 6 for an adjournment till next week to prepare a detailed J chart. Please this matter on 16/4/2025. Date chart देखिले माने जेंती 70 भाग केस आमे जानी नो
अच्छा
टाइप रो
मिलर मिलर आई विल प्रिपेयर इट
Yeah. Next.
Item 11.
Item 11 kindly pass over.
Annexure 2 को क्वास करे चाहूचुंदी, which is an order passed by the opposite party number 6. एटा कौन annexure 2 टा ଗୋଟେ notice ଟେ ଯାଇଛି ଆପଣ ପାଖକୁ ଜଣାଇ ଯାଇଥିବା ନିମ୍ନ ରାଜ୍ୟ ଅଧିକରଣ ସ୍ଥାନ ଆପଣ ପରିତ୍ୟାଗ ଉଚ୍ଛେଦ କରୁନାହାନ୍ତି ଫଳରେ ରାସ୍ତା ପ୍ରସ୍ତୁତି କାର୍ଯ୍ୟରେ ବ୍ୟାଘାତ ସୃଷ୍ଟି ହେବ ସର୍ବସାଧାରଣ ଯାତାୟାତ ଗାଡି ଚାଳନା ଅସୁବିଧା ହଉଛି ଜାତୀୟ ରାଜପଥ ନିୟମ ଅନୁଯାୟୀ 60 ଦିନ ମଧ୍ୟରେ ଦଖଲ ପରିତ୍ୟାଗ କରିବା କଥା କିନ୍ତୁ ଆପଣ ବାରମ୍ବାର ଜଣାଇଲେ ମଧ୍ୟ ବର୍ତ୍ତମାନ ଅଧିକୃତ ଜମି ପରିତ୍ୟାଗ କରୁନାହାନ୍ତି ଏହା ଫଳରେ ଆପଣଙ୍କ ଠାରୁ ନିୟମ ଅନୁଯାୟୀ ଆର୍ଥିକ ଜୋରିମାନା ଆଦାୟ ଆପଣ ବେଦଖଲ କରାଯିବ ଏଣୁ ଆପଣଙ୍କୁ ଶେଷ ଥର ଜଣାଇ ଦିଆଯାଉଛି କି ଜାତୀୟ ରାଜପଥ 55 ଅଧିକୃତ ସ୍ଥାନରୁ ଉଚ୍ଛେଦ ଘର ନିର୍ମାଣ କାର୍ଯ୍ୟ ଭାଙ୍ଗିବା ସହିତ 17/12/2024 ମଧ୍ୟରେ ସମ୍ପାଦନ କରନ୍ତୁ ନଚେତ ତା 18/12/2024 ରେ ଆପଣ ସମ୍ପୃକ୍ତ ସ୍ଥାନରେ ଥିବା ଭବନ କାର୍ଯ୍ୟକୁ ଭାଙ୍ଗି ଦେବାକୁ ବାଧ୍ୟ ହେବୁ ଏଥିପାଇଁ ସ୍ୱାଂଶ ଦାୟୀ ରହିବେ ନାହିଁ ତ ଇଏ ତ ସରିଗଲାଣି 18/12 ସରିଗଲାଣି ତ ଭାଙ୍ଗାଭଙ୍ଗି ହେଇଯିବନି ଆପଣ ଦେଇଛନ୍ତି କପି ଦେଇଛନ୍ତି NHAI କୁ କିଏ ଅପିୟର କରନ୍ତି କିଏ
Representation ଟା କାହା ବେଡେ ଦିଆଯାଇଛି କମିଶନର ଏଣ୍ଡାମେଣ୍ଟ କଣ କେତେ ନମ୍ବର this is item number 11 ତ
item number 11
representation ଟା କାହାକୁ ଦିଆଯାଇଛି representation କମିଶନର ଏଣ୍ଡାମେଣ୍ଟ କଣ ଲେଖା ହେଇଛି
ତହସିଲଦାର ଦେଲା
ନୋଟିସ ଦେଲା ତହସିଲଦାର
ଆପଣ ଇନ୍ସପେକ୍ସନ ଆଣନ୍ତୁ ଏ ଘର ଅଛି ନା ଭଙ୍ଗା ହେଇଗଲାଣି ଦେଖୁଛନ୍ତି annexure 2 ଟା ଲେଖିଛନ୍ତି 17/12/2024 ଭିତରେ ସମ୍ପାଦନ କରନ୍ତୁ ନହେଲେ 18 ରେ ଭାଙ୍ଗିଦେବୁ ତେଣୁ ହେଇଛି ନା ନାହିଁ ଇନ୍ସଟ୍ରକ୍ସନ ହେଲା this petition has been filed challenging the eviction notice dated 17/12/2024 issued by Tahsildar Biridi from opposite party number 6. On perusal of annexure 2, it reveals that if this is not noted, you have mentioned wrongly. This is not notice dated 17/12/2024 as mentioned in the cost title. এটা ତା ଦେହରେ ଲେଖିଛନ୍ତି 17/12/2024 ଭିତରେ ସମ୍ପାଦନ କରନ୍ତୁ ତ obviously notice ଟା କେବେ date
anticipated ହେଇଥିବ ନା ତା ପୂର୍ବରୁ
ଆଚ୍ଛା କଣ ଲେଖିଲେ notice date ଟା କାଟି ଯାଉ ଖାଲି ଲେଖନ୍ତୁ annexure 2 ଆଚ୍ଛା ହେଲା in which on perusal of annexure 2 ଏମିତି ଲେଖିଦିଅନ୍ତୁ on perusal of annexure 2 it reveals that the petitioner is in unauthorized occupation of the of a land over which NH 55 is going to be constructed and the petitioner was asked to vacate the place by 17/12/2024 or else the structure standing therein would be demolished on 18/12/2024. since more than more than 3.5 months कर दें, है ना? More than 3.5 months have already passed since the date of issuance of notice under Annexure 2 and the date since 3.5 months have passed since the date on which the authorities are to take action for demolition of the house and structure. Let the land and council for the state obtain instruction about
compensation दिया है ये endowment commission has received the compensation. The structure is to be removed. Disposal
about the status of Annexure 2 for them, put of this matter. Next week, Rani Period. BD, 17th ରଖୁଛୁ 17/4/2025 ଭାଙ୍ଗି ଭୁଙ୍ଗି ଦେଲେଣି ନା ଅଛି ଏତିକି ତ ଆଣିବେ ଆଉ ହେଲା।
Item 12.
We are not able to hear you. What is your prayer? Be a little louder.
No, it's on. Yes.
Make sure pending before opposite party. In notice, Annexure 3, my lord, they have been ordered that petitioner further to release his compensation amount in Annexure 3, my lord. But till date, no compensation
ଏତ ଦ୍ୱାରା ଆପଣଙ୍କୁ ଜଣାଇ ଦିଆଯାଉଛି କି ନିମ୍ନଲିଖିତ ବାସଗୃହ ସଂରଚନା ଅବଶିଷ୍ଟ ଜମି ଭାରତ ସରକାରଙ୍କ ଦ୍ୱାରା 13/1/1981 ଠାରୁ ଆଇନ ଅନୁଯାୟୀ ଭୂ ଅର୍ଜନ କରାଯାଇ ଉକ୍ତ ତାରିଖ ଲୋକଙ୍କୁ ନ୍ୟସ୍ତ କରାଯାଇଛି। ତେଣୁ ଆପଣ ନିମ୍ନଲିଖିତ ଜମି ଉପରେ ଥିବା ଘର ଓ କୁ ଧାର୍ଯ୍ୟ କ୍ଷତିପୂରଣ ଅର୍ଥ ରାଶି ମୋଟ 12,00,000 କେତେ ତାରିଖ 20/5/2024 ତାରିଖ ଦିନ 1 ସପ୍ତାହ ମଧ୍ୟରେ ମହାପ୍ରବନ୍ଧକ ଗ୍ରହଣ କରି ସେଇ ଗୃହ ଆଉ ସଂରଚନା ହସ୍ତାନ୍ତର କରିଦିଅନ୍ତୁ, ଅନ୍ୟଥା ଧାର୍ଯ୍ୟ ସମୟ ପରେ ଆଇନ ଅନୁଯାୟୀ ପଦକ୍ଷେପ ନିଆଯିବ। କଣ ହେଲା ଅସୁବିଧା? Petitioner fine.
No, did you ask for that?
My lord, representation has been pending with
The representation से जो direction देले 25 ଭିତରେ ଯାଇକି ନେଇ ଯାଆନ୍ତୁ ବୋଲି।
ଏଟା ପୁରା ଇସ୍ୟୁ ହେଇଛି ଭରତ ରାମ ରାଉତିଆ।
ଭଗତ ରାମ ରାଉତିଆ।
ଭଗତ ରାମ ରାଉତିଆ।
ହେଉଛନ୍ତି ତାଙ୍କ ବାପା।
କାହା ବାପା?
Petitioner's father, my lord.
ନାଇଁ ଆପଣ ବାପା ନାହାନ୍ତି କି?
ବାପା ଅଛନ୍ତି,
ବାପା ଅଛନ୍ତି, ବାପାଙ୍କୁ ନୋଟିସ ଗଲା, ବାପା ଗଲେଣି କଣ ପାଇଁ?
କୋ ଫାଇଲ କରିଛନ୍ତି ତା Annexure କଣ?
Annexure 14 ରେ medical report है। Page number 18 and page number 17 now।
ଆପଣଙ୍କର
serious ଅଛନ୍ତି ତ ଯାଇତା।
ନାଇଁ ଆପଣଙ୍କର ତାଙ୍କ ପିଲାପିଲି କେତେଟା ଜଣ? ବାପାଙ୍କ ଟଙ୍କା ଆପଣଙ୍କୁ କାହିଁ ଦିଆଯିବ? ତାଙ୍କ ପିଲାପିଲି କେତେ ସମୁଦାୟ? ଏଇ ଯୋଉ ଭଗତ ରାମ ରାଉଡିଆଙ୍କର where is the document to show that he is not able to go there to receive ଦେଖାଇଛି ଏଇଟା ଏ ରିପ୍ରେଜେଣ୍ଟେସନ ଆପଣ ଦେଇଛନ୍ତି। ମୋର ପିତାଙ୍କର ଶରୀର ଅସୁସ୍ଥ ଅଛି, ବିଭିନ୍ନ ପ୍ରକାର ବାପା ଲେଖିଦେଲେନି ଯେ ମୁଁ ବର୍ତ୍ତମାନ ଏଇ ଟାଇପ ର ଅବସ୍ଥା ଅଛି, ମୋର ଏଇ ହଉଛି ମେଡିକାଲ ଡକୁମେଣ୍ଟ, ତେଣୁ ମୁଁ ଏଇଆକୁ ଅଥରାଇଜ କରୁଛି ସିଏ ଯାଇକି ରିସିଭ କରୁ। No, this will not be done. Suppose there will be other sons and daughters and this old man might not be knowing anything. They should not do.
Yes, father can authorize any of the son or
Can authorize XYZ that out of the sons. आपको कहीं पैसा दिया जो
authorizing any of the person to receive the money to be accounted for in the account of the father.
বা ବାପାଙ୍କର ଯଦି ଆକାଉଣ୍ଟ ଥିବ ସେ ଆକାଉଣ୍ଟ ନମ୍ବର ବାପା ଲେଖିଦେଲେ ମୁଁ ଯାଇପାରୁନି ମୋର ଏଇ ଆକାଉଣ୍ଟ ତାର ବ୍ୟାଙ୍କ ଡିଟେଲ୍ସ ହଉଛି ଏଇଆ ସେଇ ଆକାଉଣ୍ଟ କୁ ସେ ଟଙ୍କା ପଠେଇ ଦିଅନ୍ତୁ କାମ ଛିଣ୍ଡଲା who can hand over ଦିଆଯିବ This writ petition has been filed by the petitioner Dinesh Raudia.
Raudia
with a prayer for a direction to the opposite parties number 1 and 2 for payment of compensation amount to the petitioner with employment and package of Eviction 080 decimal of homestead land under rehabilitation and resettlement policy within a stipulated time. The notice under Annexure 2, which is issued to Bharatram Raudia, the father of the petitioner, notice dated for 12/5/2023, which has been issued to Bharatram, father of the petitioner, indicates that for acquisition of a land appertaining to Khata number 778 bracket P, plot number 6230 bracket P, area acre soon 008 of Mauja, Jura Baga. The father of the petition been noticed to receive the compensation amount of rupees 11,249 38 paisa appearing before the authority on 15/5/2023. Learned counsel for the petitioner submits that the father of the petitioner is suffering from serious ailment for which he is not in a position to appear before the concerned authority to receive the compensation amount. And for such reason, a representation was submitted before the general manager, Mahanadi Coalfields, Lakhanpur area, Brakama, opposite party number 2. With a request to hand over the compensation amount to him. There is no application before us by Bharatram Raudia authorizing the petitioner to receive such compensation amount if the father of the petitioner is really suffering from ailment. He could have filed appropriate application giving authorization to any person to receive such compensation amount, which has not been done in this case. Therefore, the prayer of the petitioner to dispose of the representation by the opposite party number 2 and to give the compensation amount to him cannot be accepted. Accordingly, the writ petition stands dismissed.
My lord, there is another annexure, different figure are there. Annexure 3. Second notice has been given in which the compensation amount has been different, madam.
ଗୋଟେ ହଉଛି annexure 2 ରେ ହଉଛି 11 ଲକ୍ଷ କେତେ?
Annexure 3 ରେ madam
ନାଇଁ ନାଇଁ କଣ ସେ land ଟା ସମାନ ତ?
ସମାନ line.
ଆଚ୍ଛା 778 6230 और land ଟା ହଉଛି ଏକର ଜାଗା କୋଉଠି ମୌଜା ବେଲ ପାହାଡ ଯୁଗ ଯୁଗ ବରା ଯେ ଏଟା ଗୋଟେ ବେଲ ପାହାଡ ଲେଖା ହେଇଛି ତାପରେ ଆଚ୍ଛା 8 ଡେସିମିଲ ଟା ଲେଖା ହେଇନି ସେକେଣ୍ଡଟାରେ ଉପରଟା ଦେଖନ୍ତୁ annexure 2 ରେ କ୍ଲିୟରଲି ଲେଖା ହେଇଛି 8 ଡେସିମିଲ ଏକର 0.008 ଡେସିମିଲ ସେଇଟା ଲେଖା ହେଇନି annexure 3 ରେ ସେଟା ତ ଲେଖା ହେଇନି ତେଣୁ ହୁଏତ ଅଲଗା ହେଇଥାଇପାରେ କିଏ ତା ଭିତରେ କାହିଁ ପଶିବ ହେଲା ତ ଆମେ ତ କହିଲୁ ସିଏ ଆପ୍ଲିକେସନ ଦେଲେ ଯିବେ ଆଉ କଣ ଆଚ୍ଛା ଏଇଟାକୁ ଲେଖିଦିଅ another notice has been also annexed to the writ petition under annexure 3 in which also the father of the petitioner was noticed to appear before the authority on 25 no 25/2024 to receive the compensation amount rupees 12 lakh 14,200 ନାଇଁ annexure 3 ଟା ମାତ୍ର ଆସନ୍ତା ଏକ ସପ୍ତାହ ମଧ୍ୟରେ ଆଚ୍ଛା within a week from 25/24 ମାନେ ଗୋଟେ ଫିକ୍ସ ଡେଟ୍ 25/2024 ରୁ ଏକ ସପ୍ତାହ ମଧ୍ୟରେ ଗ୍ରହଣ କରିନେବ ହେଲା and the land particulars have been mentioned therein as Mauja Belapahada bracket with Jugavara Khata number 778 plot number 6230 bracket part कर दियो है ना ठीक खाली कर दियो तापरे सेटा लिखे दियो हाँ yeah madam what is your name S Mahapatra yes Mahapatra yes next
item 13
May I please, my lord, in this case, the petitioner has challenged the order dated 10/7/2020 made annexure 2 running phase 15 passed by the Odisha Real Estate Regulation Authority, where an amount of 1 crore has been awarded against me. The short point of law involved in this case is that the agreement
appeal nahi
appeal achi, that is also I have annexed that is running page 23 that there is statutory amount of 30% has to be deposited but while the this petition 31 of 22 was filed at that time I was inside the custody so I could not give any show cause or thereafter that was
you filed the appeal you filed the appeal
yes my lord I have preferred appeal that is running
appeal ta kebe file kale
that is in 24 my lord that has been disposed of on date
66 of 2024 but he has not deposited the statutory
30% of that amount which has to be deposited.
The order was passed.
So that has also been gone against me. My humble submission is that the RERA Act came into effect in the year 2016 that operated in the 2017. So far the petition of the OP number 3 is concerned, that was the agreement between me and him and the sale deed all are of 2012. So whether the RERA Act will be applicable retrospectively to the action of the 2012, that is the short.
You can raise this bond before the appellate authority.
I was in the custody.
Deposit it. You deposit the money and you can go.
So I was in the custody. I could not raise that point.
Not that point right now.
That has been already dismissed, my lord.
Right.
No. We can set aside the order provided that you file an undertaking that you deposit the amount. And obviously, in that way, the other side will not have any objection.
One thing, my lord, let it come next week so that I will take instruction from my client regarding deposit so that.
Okay. This writ petition has been filed challenging the order dated 21/10/24 passed by the Orissa Real Estate.
10/7/2023 and also 21/10/2024 both order I have challenged in this case.
21/10/2024 order pass କରିଛନ୍ତି ତାପରେ ପୁଣି ଆଉ କଣ?
ନା ପୂର୍ବରୁ ଯୋଉଟା ରେଫରେଟି ଫାଇଲ କରିଥିଲେ ସେଟା ବି ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛି ଦିଟା ଅର୍ଡର
ଠିକ ଅଛି ଆଜ୍ଞା
ଏଇଟା ତ ଲାଷ୍ଟ ଅର୍ଡର
thereby confirming the order.
Yes.
yes yes
No, ବ୍ୟସ୍ତ କାଇଁ ହଉଛନ୍ତି? Passed in by the Odisha Real Estate Appellate Tribunal, Bhubaneswar in OREAT appeal number 66 of 2024 in dismissing the appeal as not maintainable in absence of deposit of the statutory amount by the petitioner and thereby confirming the order dated 10/7/2023 passed by the adjudicating officer Oira Bhubaneswar in AOCC number 31 of 2022. The learned counsel for the petitioner submits that he may be given some time to obtain instruction as to whether the petitioner is ready and willing to deposit the statutory amount before the appellate tribunal, Orissa Real Estate Appellate Tribunal, Bhubaneswar or not. Kebe rakhiyo phone?
24th
Put up this matter on 24th of April 2025. Yes.
Item 14.
Item number 14 on behalf of Mr. Rehabilitation, taken up 1 week.
1 week after. Is it first station Aguras?
Get order.
Achha. Mr. Rautrai ये अपनो power नहीं है तेरे?
No.
अच्छा, what is your name?
Expert.
हाँ?
His grandmother expert.
ठीक है, अपनो नाटक लिखी गई. So makes mention on behalf of Mr. N.R. Rautrai for adjournment of the matter for 2 weeks. Taking the date they don't say 5th of May 2025.
Yes. Admission matter 24th or 25th.
नहीं नहीं अपन की एक्सपर्ट क्वेश्चन का क्वेश्चन
हाँ एक्सपर्ट क्वेश्चन तो 21 को सर जो भी
हाँ तो यू वांट इट 24 हाँ बोला 24 से क्वेश्चन 24/4/2025 ठीक है
Item 15.
filing this now through withdrawal of the
simple withdrawal. The reflection E prior to the assumed file syndrome
Item 16.
I'm sorry to interrupt my.
Yeah.
Item 14 it was adjournment.
14 years there is a bereavement in the family of Mr. Rautrai.
Oh,
So he wants it after 1 week. We have posted it to 24/4/25. We are mentioning your name.
Yes, sir.
Item 16.
Please, madam. Lord, IA 2789 of 2025 at flag A. That is for condemnation of delay.
This is item number
16.
16.
Union of India versus.
It's all right. Which application is for condonation of delay?
My lord, 2 789.
Whether any delay has been pointed out by the stamp reporter? Reporting him. Stamp reporting. जो objection out है reception to be not filed.
Deficit में defect नहीं होती as per SR
थोड़ा सा ही नहीं बोले सीट में stamp
subject to risk नहीं assessment
এটা কোন ଦେଖିଲେ এটা কোন stamp reporting ରେ complete stamp reporting ନା objection ଦେଇଛନ୍ତି. What is the procedure? Objection ଦେଲେ reporting stamp the records, digital records, for example, we find that the stamp report
sleep
stamp report sleep na कौन सा लिखा हुआ report sleep is not annexed or filed is not available record. Let the same be placed. Put up this matter on 16th of April 2025.
But 16th April,
Will not be there. Tell us which date.
Either 15th or 17th.
No, 15th it can be, 17th all right. 17/5/2025. All right. You are Mr. Pushparaj Bharadwaj.
My lord.
Mr. Pushparaj Bharadwaj and Central Government Council though wanted to place the application for condonation of delay by IN number 2789 of 2025, but you find that the stamp report is not available. Just send me the request. Yes.
Item 17.
This was died on date 7 March 2025. I have substituted them for 2 weeks time be granted.
The petitioner has died.
Man.
Manjulata Sahu.
Man. 7/3/2025.
File के
person
5501.
Substitute necessary.
Yeah, just a minute. the learned counsel for the petitioner submits that the petitioner has expired and he wants to file a substitution application, and for such purpose 2 weeks time is required. Release this matter in the information from 5th of May 2025. Yes.
5th of May.
5th of May 2025. है ना?
Item 19.
Mr. Shukant Kumar Naik. Pass over from.
Item 20.
The petition filed a representation on dated 14/25 filed annexure 8 at page 36-37 that has been pending before the OP number 3, that means collector's input. Can be directed to the OP.
What representation?
Annexure 8. Page
No, what is the representation?
Representation to issue displaced identity card and
what the?
displaced
Displaced identity card. Under
which provision?
Around our police 2002 of IOC.
Shows the provision where such a certificate can be granted by.
Have you mentioned in your list? Government?
Lordship, please annexure 4, page 26. 5.0 eligibility criteria for rehabilitation benefit. Criteria 1. A family has been taught.
Who paragraph?
Annexure 4, page 26.
5.2.
5.2. A family satisfying any one of the following criteria has been considered as eligible for rehabilitation benefit. Criteria 1. A family has been torn, displaced, and hence eligible for rehabilitation benefit only if such family has been a permanent resident of Orissa and ordinarily residing in the project site for at least 3 years prior to 1st January 99, which is considered the date of publication of notification under Section 4(1) of Land Acquisition Act 1894 as pertaining to the project site and is being displaced from the project site on account of acquisition of their homestead land. May kindly annexure is page 18. Clause 9. Amount allowed for teach, house or any other immovable thing. House payment already has been paid, but displaced card not issued till date.
No, that is to be issued by collector ବୋଲି କୋଉଠି ଅଛି? ଆପଣ ଯୋଉ authority ଙ୍କ ପାଖରେ representation ଦେଇଛନ୍ତି, he has got the power to issue such certificate. Where is that? Is there anything that who is to issue that certificate?
Certificate issued that land acquisition collector Jagatsinghpur.
କୋଉଠି ଆପଣ କୋଉ basis ରେ କହିବେ ନା? ଆପଣ ଯୋଉଟା ପଢିଲେ ସେଇଟା କହୁଛି ଯେ ଏଇ ଫ୍ୟାମିଲି କୁ କୁହାଯାଇ ପାରିବ ଡିସପ୍ଲେସ୍ଡ ଫ୍ୟାମିଲି। ତାର ଯଦି ସେ ପ୍ରୋଜେକ୍ଟ ସାଇଟ୍ ରେ ସିଏ 3 ବର୍ଷ ଧରି ରହୁଥିବ ପ୍ରାୟ ଟୁ ସୋ ଏବଂ ସେ ଡିସପ୍ଲେସ୍ଡ ହେଇଥିବ, ଏଇ ତାଙ୍କୁ କୁହାଯିବ ଠିକ ଅଛି ଆପଣ କେବେଠୁ ରହିଛନ୍ତି ସେଟା ଦେଖେଇବେ, ସେଗୁଡା ତାଙ୍କୁ ସେ ଭେରିଫାଏ କରିବେ, ତାପରେ ଭେରିଫାଏ କଲା ପରେ ସେ authority concerned display certificate ଦେବେ। But the collector is to do this thing. Where is that?
Where is that? Nothing has been. Nothing has been pointed out to the RR policy, but at the time of for the purpose of land acquisition, the authority concerned land acquisition and IOC.
Council, once we issue such a direction to particular authority, he must have got the power to issue such certificate. If he has not got no power, then if we pass the order, whether it would be a legal order, somebody has no power to issue such certificate, I will ask him to do the same. Can we pass such order?
I am Odia khali kohuchi just.
Odia re kai kohuchani? English re kuhuntu.
Nahi kohuchi ke Odia. ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ଯୋଉ ଜମି ଆଉ ଘର ଅଧିଗ୍ରହଣ ହଉଥିଲା କଲେକ୍ଟର ଆଉ ସ୍ୱତନ୍ତ୍ର ଭୂ ଅର୍ଜନ
ଆମେ ଆପଣଙ୍କୁ ଓଡିଆରେ ହିଁ ପଚାରୁଛୁ
ଆଜ୍ଞା
ଗୋଟେ ଅଥରିଟିର ପାୱାର ନକୁ ହାଇକୋର୍ଟ ଡାଇରେକ୍ସନ ଦେଇପାରିବ କି ସେ ସାର୍ଟିଫିକେଟ ଇସ୍ୟୁ କରିବା ପାଇଁ?
ନାଇଁ ଆଜ୍ଞା
ତେଣୁ ଆମକୁ ଦରକାର କୋଉ ପ୍ରୋଭିଜନ ରେ ଅଛି ଯେ କଲେକ୍ଟର ଏଇ ଟାଇପ ର ସାର୍ଟିଫିକେଟ ଦେଇପାରିବ। ଯଦି ନାହିଁ ବୁଝିକିନି ଆଉ ଟିକେ ଡିଟେଲ ଷ୍ଟଡି କରିକିନା ଆସନ୍ତୁ।
ନାଇଁ
Displaced certificate can be issued by the collector.
ଆଜ୍ଞା ଗୋଟିଏ ମିନିଟ୍ ଯେ ଆଜ୍ଞା ଯୋଉ ଆନେକ୍ସର 8ଟା ପେଣ୍ଡିଂ ଅଛି whether ଯଦି
We will not direct
ମାନେ
disposal
roving
of the
inquiry. You'll be going on a roving inquiry by passing an order from this court. Why don't you see the rehabilitation policy? It is there. You are not going through it. Kindly go through it and come. I can find it out, but I will not find it out for you. You are not prepared. You get prepared and come.
This repetition has
We have
been
seen
filed
it, but we will not pass order unless you see. You get prepared.
with the following prayers.
ଅଛି ସେଇଥିରେ ଆପଣ ପଢିବେନି ଆମେ କଣ କରିପାରିବୁ? You prepare.
କଲେକ୍ଟର ଏଲୋ ହିଁ ଇସ୍ୟୁ କରୁଛନ୍ତି
ଅଛି ସେ ପ୍ରୋଭିଜନ ଟା ଦେଖ।
The land and
କାର୍ଡ
counsel
ଇସ୍ୟୁ ଅଛି କାର୍ଡଟା ଆଜ୍ଞା ସବମିଟ କରେଇଦେବି
the land and counsel for
ଦିଅନ୍ତୁ
the
ଦିଅନ୍ତୁ।
କରେଇଦେବି ନେକ୍ସଟ ଡେଟ୍ ରହୁଛି କାର୍ଡଟା ଇସ୍ୟୁ
land and counsel for the petitioner prayed for disposal of the representation under Annexure 8, which has been submitted before the collector Jagatsinghpur, opposite number 3. Land and counsel for the petitioner placed the rehabilitation and relief plan of Indian Oil Corporation Limited, Paradip Refinery Project Paradip, dated 2/12/2002, in which clause 5 deals with eligibility criteria for rehabilitation benefits and how a family can be termed as displaced family has been mentioned in clause 5.2. We put a pertinent question that whether there is any provision that the collector has to issue the displaced certificate for which representation has been filed before opposite party number 3, the land and counsel for the petitioner seeks some time to show the provision. Put up this matter on
next week
16th of April 2025. Yes.
Item 21.
Yes. This matter was there if you notice on the 20th of March. Notice wanted me to file a revised dates of events. That I have filed on 23 minutes. Notice wanted when the petitioner got married.
What is the prayer in this petition?
Well, petition is they have rejected my prayer for rehabilitation benefit extension. If you also kindly come to page 56.
You are challenging the order dated 18/12/2024.
Yes.
Which is that annexure?
That order is annexure 11, page 54.
Annexure 11. Okay.
Well, just kindly see last paragraph. The stand of the government. On the contrary, an advocate for the opposite party argued that the petition on section 31 of funds is not maintainable as per the guideline issued by Secretary of Government of Orissa 2/17/1989. The said later it has been clarified that family includes husband, wife along with unmarried children but does not include a major son who has been separated from family before the date of notification on section 4 of the Act of the area. In such scenario, separate son would be considered a separate family. In the present case of 4/1, notification was published on 7/11/1929, and by that time the ROR stood recording name of Daswati Bhutia, and the present petitioner was already married. Since the recorded tenant Daswati Bhutia and his son Dwari Bhutia has already expired by the time when the rehabilitation and retribution benefit was provided to family members of Vincent Bhutia, Dwari Bhutia under category A, but this is brother of the petitioner. Then last paragraph. On the analysis of the Uniform Guidelines Government of Orissa stated above, it has been determined that a married daughter whose marriage occurred prior to further notification and who resides with her husband in a village that has not cannot be classified as a land house. The next page number, page 56. In the instant case, it is undoubted that the petitioner Parvati Rao, daughter of Dwari Bhutia, was married to Makadhaj Rai of Kupuranga village before further notification of CBA Act of 1957. He was residing with her husband, which has never been acquired by himself. Therefore, based on this fact, petitioner cannot be considered land house. If you also look at the notification which has referred to me, that I have flagged email.
Paravels comments in this. I'll say.
You received
Paravels
comments.
The Land and Counsel for the petitioner has filed the revised date chart, and same has been also supplied to the Land and Counsel for the state.
Yes,
Nine, but you.
Revised date card.
I've already given you.
ଶୁଣନ୍ତୁ ତାପରେ ହଟା ମାରିବେ ସାଙ୍ଗେ ସାଙ୍ଗେ ହଟା ମାରିଦେବେ ରିଭାଇଜ ଡେଟ୍ ଚାର୍ଟ କୁହାଯାଇଥିଲା କୋର୍ଟ ପାଇଁ ଫାଇଲ କରିବାକୁ ଆପଣଙ୍କୁ କପି ଦେବାକୁ କୋର୍ଟ ପାଇଁ ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କୁ ଦେଇଛନ୍ତି ନା ନାହିଁ ଉପରେ ଲେଖା ହେଇଛି ହେଡିଂ ଲେଖା ହେଇଛି ରିଭାଇଜ ଡେଟ୍ସ ଅଫ ଇଭେଣ୍ଟସ ବୋଲି ଏମିତି ଗୋଟେ ଲେଖା ହେଇଛି ନାଇଁ ଯଦି ଗୋଟେ କପି ଦିଅନ୍ତୁ let a copy of the same be supplied to the Land and Counsel for the state. Achha, copy supplied to the in court. This writ petition has been filed by the petitioner Parvati Rao, challenging the order dated 18/12/2024 passed by Sub-Collector Administrator Talcher in RR Miss Case number 6 of 2023 under Annexure 11, holding wherein it is held that the petitioner claim for employment and RR benefit in the land acquisition is devoid of merit, and accordingly the same was rejected. Peruse the date chart at the Land Counsel for the petitioner, issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Counsel for the state accepts notice on behalf of ଆପଣ କାହା କାହା ପାଇଁ ଇଏ କରିବେ 1 ଆଉ 4 ପାଇଁ ନା ନାଇଁ MCL ଟା ଆପଣ କରିବେ
ନୋଟିସ
ଆଚ୍ଛା ତାହେଲେ କେବଳ ଆପଣ 1 ପାଇଁ appear କରିବେ
1 ଆଉ 4
1 and 4 ଆଚ୍ଛା 1 and a copy of the writ petition be served on the Land Counsel for the state. So far as opposite parties number 2 and 3 are concerned, requisites for issuance of notice on those opposite parties we filed by next week. Matter be listed after 4 weeks.
2 weeks.
4 weeks So you in the meantime counter affidavit we filed in the meantime. Mr. One thing, Mr. Tripathi, we find that the compensation amount has been disbursed to your brothers.
Yes, sir.
So why have you not made them parties?
Well, that part, whatever my brother was entitled to, he has got it. So for my portion is 1 acre 67 lakh, 67 decimal has not been paid, and that was the finding of the inquiry.
You ଜମିଟା acquire ହେଲା ଯୋଉମାନେ ପାଇବା କଥା compensation ଯଦି ଆପଣଙ୍କୁ exclude କଲା ତ balance amount ଟା ସେମାନଙ୍କ ଭିତରେ equally distribute କରିଦେଇଥିବେ ଯୋଉ ଭାଇ ମାନଙ୍କ କଥା ସେଇଥିପାଇଁ
ଗୋଟେ ଭାଇ ଗୋଟେ ଝିଅ ଗୋଟେ ଭାଇ ଗୋଟେ ଭଉଣୀ
ତ
ଭାଇ portion ଟା he has already taken
ଭାଇ ତ entire ନେଇଯାଇଥିବ ଯଦି ଆପଣଙ୍କୁ ଇଏ କରିଦିଆଗଲା ତାହେଲେ ଭାଇ ନେଇଯାଇଥିବ entirely.
No, 167 million has not been given. That was the record also. That was the inquiry report.
But portion of land has not been.
No, that
compensated.
rehabilitation benefit and compensation have been paid to me. That
So
was
the-
the claim.
So area of land has also been apportioned.
Acquired. No, they have acquired. If an
No, no.
can come to page 22. It will be clear, madam. Page 22. Para 3 minute first line. Parvati of Dr. Franco has lost 1.67 agriculture and homestead land. সেই পোর্শন অফ পেমেন্ট হই
And the item 2 has been
item 2 মানে my husband page 23 last word 1 পারা যাবে না I am entitled to that sale.
Yes, next.
Item 22.
I'm challenging annexure 8, which is at what's page 158.
Well, yesterday, item 17.
No, that is different, completely different.
I'm saying, yesterday, item 17. The same petitioner.
A petitioner may be said for different cause of action.
Here, he has been penalized for illegal mining, which I have to take instruction.
No.
So lordship should see annexure 8.
The area which has not been allotted to him, he was doing illegal mining in that area.
Go for criminal action, whatever is possible besides other than in mining. You can proceed.
No, they have neither proceeded, they have neither issued a so-called.
Let us see what is this matter about.
Fine imposed on him.
We'll see.
Lordships may see annexure 8.
Lifting of sand beyond lease area by using
Dredging. You are therefore directed to deposit the fine amount. So no inspection report, no so-called notice, and this also was never served to me. I came to know of it when they filed this in a proceeding before the NGT, where the issue was regarding this mining, whatever the sand mining areas and all that. There they annexed this document from which I got the information only regarding this demand has been raised against.
So you are challenging annexure 8.
Annexure 8.
9 is a reminder.
9 is just the reminder of the same. And if your lordship should see, just the next page is annexure 10, which is their normal communication regarding penalty and the fines whenever it is charged. And interestingly also, the quantum, if your lordship should see.
No, whether you have been allotted this area or what?
No, nothing has been mentioned.
So that your challenge is on what then? You have not been allotted the area at all.
No. What annexure 8 says that in the area which has been given to me, but that area has not been mentioned. No inspection report, no show cause. Absolutely nothing is there except for this demand of 2 lines.
Annexure 8, if you come to that.
Yes, my lords.
Subject matter is lifting of sand
beyond lease area by using dredging machine that may not be used.
From the joint inquiry, it revealed that you have extracted so sand beyond the lease area by using dredging machine. Okay. You are therefore.
So nothing, no so-called.
No, you have not been shared with the joint committee report.
Absolutely nothing. Even this was also not communicated to me. I came to know of it when they filed it in another proceeding before the NGT, which reply I have also annexed before your lordship.
What is this item number? Is you annexure 10?
Well, annexure 10 is given to another person, showing the rates. What is the given or the quantum mentioned in therein? If your lordship should come to page 161, there the mining extending beyond the permissible limit is 7-9, mid of the third paragraph, my lord, where it starts with you have not taken any prior permission. At page 161.
No, once the this notice has been issued, dated is 23/5/2023.
Yes.
And the reminder is 4 months there, 25/7/23. That is annexure 9.
9. Those have never been served on me. And prior to that also, no so-called notice, no inquiry report, no joint inquiry, of which I have been, my lord, I should have been communicated at least that there will be a joint inquiry. Absolutely nothing there.
What is those grounds you have taken?
Yes, my lord. If your lordship should see, starting from paragraph 15, my lord, 14. Primarily, no such notice was ever served upon the petitioner until he became aware of such notice on 8/3/24, when the reply was filed by the State Pollution Control Board, Orissa, before NGT in OA number so and so. Before that, the petitioner was not aware of the later dated so and so issued for excess excavation. Moreover, the reminder letter was also never issued to the petitioner till present date. Such a letter was created so and so, my lord. Apart from that, I have also on the next page I have mentioned that opportunity should be granted before issuing notice of excess sand excavation. No opportunity of hearing was ever provided to the petitioner, nor was any so-called notice ever issued to the present petitioner on this aspect. No task force as constituted by the Mines Department has ever visited the site for carrying out an inspection, nor has the task force ever issued a notice to the present petitioner for making and conducting an inspection.
So you are assuming that such a demand may be made against you?
No, it has. They say it has already been made.
Where?
That, my lord, annexure 8.
No, you say that this annexure 8 you have got it from the NGT?
NGT.
Where?
Because they filed it in the NGT by the Pollution Control Board, in which this was attached. And we are a party to that
proceeding. No, so directly no notice. Absolutely not. Then why you or it? You got a notice extracted from a different proceeding, no, because, and assuming you to be the...
Based on this communication, tomorrow NGT will part the order.
Assuming, that is what I am saying. You are assuming that such a notice may be there.
And otherwise also, my lord, tomorrow if I ask for renewal of my lease or I apply, they will not grant me.
These are all in anticipation. No, it is a contingent.
The question is, once this has come to my notice, once it has come to my notice, if I don't challenge in the NGT proceeding where I am a party, yes, my lord, all signed my lord.
So you take instruction in the matter. So, this writ petition has been filed by the petitioner, S.K.Sahoo, challenging the order dated 23/5/2023 and 25/7/2023 issued by the opposite party number 4 and opposite party number 5 under annexure and time respectively, and to quash the raising of the fine amount of rupees 38,56,710 in excavating 2900 cubic meter of sand beyond the lease area, which was never issued to the petitioner. The Learned Counsel, Mr. Nonderland Senior Advocate, submitted that no such notice has ever been served upon the petitioner until he came to aware of the same on 3/8/2024, when the reply was filed by the State Pollution Control Board, Orissa, before NGT in OA number 91 of 2024. And before that, the petitioner was not aware of the later dated 23/5/2023 issued for excess excavation, and the reminder letter dated 25/7/2023 was also never issued to petitioner till today. It is the case of the petitioner that an opportunity should be granted to before issuing such notice of excess sand excavation, and when no opportunity of hearing has been provided to the petitioner and no show cause notice has been issued to him, and no task force was ever constituted by the mines department to visit the site for carrying out inspection, issuance of such notice suffers from illegality, and therefore the notices under Annexure 8 and Annexure 9 are liable to be passed. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Counsel for the state accepts notice on behalf of all the opposite parties. Extra copies of the writ petition be served by the Land Counsel for the state. Put up this matter 4 weeks after you file your counter affidavit. Yeah.
So maybe in the meantime, it's because
They have
might
not
rely
issued-
on that.
They have not. If
No,
they come,
not action has not been taken.
no,
but it's a-
IA, we have kept it pending.
Yes.
If any moment they comes, you come with it.
All right.
Because
Deeply
these are the notices of old notices.
Yes, I understand.
Yeah, apparently it is vague. Apparently it is vague.
Vague.
But let them use.
No, absolutely.
Yes. Next.
Deeply.
Item 23.
Legal office. Petitioner is retired due to employment. Retired on October 2013 due to wrong fixation of pay in 2006, and he from his discharge an amount of rupees 2,02,000 from us has been withheld, and he challenged the same before the tribunal. Tribunal has increased the rejection, and the similar issue where tribunal has allowed, and that was challenged before the court by the Union of India. Your Lordship has passed similar order regarding withheld group C employee, whether recovery or withheld can be made or not. And also that apartment law, the latest judgment of the appeals court in 4th April, that recovery cannot be sorry, Mayor.
No, it's all right.
Supreme Court judgment.
So the payment of excess amount is not the fault of yours.
Yes, ma'am.
That is why.
Yes, ma'am. That is the same similar employee, similar department. They have the tribunal has allowed the Union of India.
Rafiq Messiah.
Yes, madam. Obliged.
No, recently one judgment coming to the Supreme Court. If the recovery person is concerned, it is required to be examined manner. I've just gone through it here. He said Supreme Court, this overall Supreme Court said that if you recover the government cannot recover the same for the employee. But
what I do are issue.
No, if it is not attributed to
ଆପଣ ତାକୁ ପଇସା ଦେଇଦେବେ ସେ ତାର କିଛି ଦୋଷ ନାହିଁ ତାର ସେ ଖର୍ଚ୍ଚ କରିଦବନି ବର୍ତ୍ତମାନ ଆସିକି କେତେ ବର୍ଷ ପରେ ପୁଣି ରିକଭରି କରିବେ
in the event of a misrepresentation you can say
ମିସରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇ ପଇସା ନେଇଯାଇଛି ତାର ଅଲଗା କଥା ଆପଣ ସିଏ ଭାବୁଥିବ ଏଇଟା ତାର ଜେନୁଇନ ଇଏ ପାଇବା ଆପଣ ଦେଲେ ତାର ଆକାଉଣ୍ଟ କୁ ଆସିଲା ସେ ତାକୁ ଖର୍ଚ୍ଚ କଲା ହଠାତ୍ ତାର ସେ ରିଟାୟାର୍ଡ କଲା ପରେ କିଛି ବର୍ଷ ପରେ କହିବେ ରିକଭରି କରିବେ ତ this is a retired employee.
Yes, ma'am.
The writ petition has been filed by the petitioner so challenging the order dated 30/9/2022 passed in OA number 471 of 2018 by the London Central Administrative Tribunal, Shortlist Cutter. So also the order dated 1/8/2018 by the opposite party number 2 under Annexure 4. The Land Counsel for the petitioner submits that similar matter was has been dealt with by this court.
But the Supreme Court defined it as executive, non-executive.
Yes, whether you can file, you will file.
Yes.
In WPC number 23351 of 2024, in which relying upon the decision of the Honorable Supreme Court in case of State of Punjab versus Rafiq Mashia, White Wasser, reported in year 2015, Supreme Court 696. It has been held that the recovery from the employees belonging to Class 3 and Class 4 service bracketary or Group C and Group B service bracketary who have been mistakenly paid by the petitioner in excess of their entitlement would be impermissible in law. The Land Council submits that in the said writ petition, the Union of India challenged the order passed by the Land and Central Administrative Tribunal and this court dismissed the writ petition and directed the Union of India to immediately refund the withheld amount to the opposite party within a period of 2 weeks. The copy of the order is taken on record. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Mr. Pari appears for so. Extra copies of the writ petition will be served on the Land Council for the Union of India. Matter be placed after 4 weeks. Counter affidavit, if any, be filed in the meantime. अच्छा ये दावोड सुप्रीम कोर्ट for decision region सेटा मध्य साइड करते हैं on similar matter.
Item 24.
Here the petitioner's land was acquired by the BMC under the economic plan in the year 2020 without giving any compensation to the petitioners. As per their calculation, the amount is 6,53,88,000 units.
Where is that calculation?
It's 31 units.
Who has made that calculation?
The BMC, collector could that. As per the instruction with regarding to the BMC commission. 6,53,80,189 rupees units. The petitioners made several attempts to representation to calculate the revaluation of the property.
It has been that has been calculated by this is issued by the Commissioner BMC.
Yes, sir.
And there it has been ordered that you are to execute the sale deed in favor of Lord Lingaraj Mahaprabhu
yes, sir.
in lieu of compensation.
Yes, sir.
So you are ready to execute the sale deed?
like as per the provision of section 38, Your Lordship, the compensation should be made prior to take possession, Your Lordship. Now the land was already has taken possession by and the structure was already demolished by the authority, Your Lordship.
You have not received this amount.
No, Your Lordship.
So, who is to opposite party number 1, 2, Bhubaneswar municipality separate council?
Separate council.
बाकी तो
1 and 2.
1 and 2 अपन appear करिए. DM शिक्षा दी panel लेना नहीं. हाँ.
There were 6 nights.
जने एकुटिया अछंती ना notice जीवो.
CMC and BMC both. He is for CMC. It is BMC.
Bhubaneswar municipal corporation. Like is for Cuttack municipal corporation. Nine notice job. Look on this writ petition has been filed by the petitioner Lakshmi Narayan Das Chaudhary for a direction to the opposite party number 3 for payment of compensation and actual acquisition amount as calculated in the order dated 16/23 under Annexure 7. The Land Council for the petitioner placed Annexure 7, wherein it appears that the Commissioner BMC, taking into account the guidelines of the government in R&DM letter number 4541 /R&DM dated 27/1/2020, has calculated the total compensation payable to the petitioner as RS 6,53,58
6 crore.
6 crore 53 lakhs 88,189. It's a word selected. And direction was issued to the petitioner to execute the sale deed in favor of Lord Lingaraj Mahaprabhu in lieu of the compensation to be payable by the BMC. Land Council for the petitioner submits that since the compensation amount is to be paid has not yet been disbursed, even though the petitioner is ready and willing to execute the sale deed, he could not do the same. Issue notice on the question of admission indicating therein that the matter shall be disposed. Stage of admission, Land Council for the state accepts notice on behalf of opposite party number 1 and 2. Extra copy of the writ petition be served on the Land Council for the state so far as opposite party number 3 and 4 are concerned. Requisites for issuance of notice on those two opposite parties be filed within a week. Matter will be placed 4 weeks after thereafter. Counter affidavit, if any, be filed in the meantime. Yes.
Item 25.
The petition's land is acquired by NS26 for construction of bridge, and the Tahsildar from Land Action Officer issued a notice to the petitioner. Can you see the Annexure 1, page 15, my lord? Notice dated 11/12/24. And Annexure 2 with my arrow.
Chandra Agarwal.
Document what's the receive the amount, compensation amount as per market price. So petition has not received.
No, if you have not received and you are claiming a higher compensation,
yes,
and it's a NH Act, then you are to file appropriate application 3G5 बोले देखिए provision का भी national highway যেটা আরবিট্রেট ডিসাইড করবে। If the amount determined by the competent authority under subsection 1 and subsection 2 is not acceptable to either of the parties, the amount served on an application by either of the parties be determined by the arbitrator to be appointed by the central government. The 10.6 application the
I will petitionally file that.
The writ petition has been filed by the petitioner Chandra Agrawal for a direction to the opposite parties to disburse the adequate compensation to the petitioner for acquiring his land by plot number 763/1253 of Mauja Jalko, Tahsil Kesinga, in the district of Kalahandi. Land Council for the petitioner placed Annexure 1, in which the Tahsildar land acquisition officer Kesinga from opposite party number 3 has determined the compensation amount to be 2,37,620. Notice which is dated, for example, 11/12/2024 under Annexure 1, and directed the petitioner to appear on 17 or 16/12/2024 to receive such amount with documentary proof. The Land Council for the petitioner submits that since the compensation has been determined at a lower side, the petitioner has not received this help. He has filed the copy of the ROR as Annexure 2. Section 3G, 5 and 6 of the National Highways Act 1956 reads as follows. Quote for them. In view of such provision, the Land Council for the petitioner seeks permission to withdraw the writ petition to approach the appropriate authority for enhancement of the compensation amount. Accordingly, the writ petition is withdrawn. Yes.
Item 26.
You have got no power in this case. Please give your name. So and so appearing for Hemant Kumar Rao, advocate, 6 for an adjournment next week. Madam, it will be listed on 16th April 2025. 16th April 2025. Yes.
Item 27.
Okay.
Yes.
My lord, this writ application has been filed with a prayer for seeking a direction to the opposite party number 3 and 4 for payment of compensation PDF amount in accordance with the Annexure 4, that is the proceeding of the RTDSC meeting. My lord, the petitioners are the land outstanding. The land has been acquired by the Mahanadi Coalfields for the project of Bharatpur area in the district of Angul under Annexure. So compensation has already been paid. They have already received the compensation. While taking the possession of the building, my lord, they have to pay the compensation which has already been sanctioned. In the meantime, the father of the petitioner has been died. Therefore, they will not pay the said amount. And it is decided under Annexure 5, my lord, the relevant portion is at 24, my lord, issue number 6. PDF debits to the heirs of the deceased petitioner. Annexure 5. My lord, it is decided in the RPDSC meeting, my lord, that the petitioners are entitled to get that benefit. May I read, my lord? While presenting the issue, that is the issue number 6,
PDF benefits to heirs of deceased PDF. While presenting the issue of the committee, the collector Hon'Ble submitted that it concerned the succession right of the deceased PDF. According to the Hindu Succession Act 1956, the successors of the deceased PDF are entitled to receive an equal share of their father's benefit. The Director Personal MCL informed the committee that the MCL pays rehabilitation benefit to the PDFs only if the PDF has undergone a shift. If the father died before the shift, there was no right to transfer in the first place. According to the recommendation of the 13th RBDS NDSC, MCL presented the matter during its 270
last paragraph.
After thorough discussion, it was agreed to provide the RR benefits of the deceased PDF to his or her successor according to the Hindu Succession Act 1956, regardless of whether the deceased PDF has moved or not.
So the succession certificate is to be obtained from the competent court.
I will produce that certificate before the authority. I will produce that certificate.
No. Have you already made an application before the authority for this with succession certificate? No.
No.
Then
how केमती
करिवे?
Direction केमती issue हो?
You file you make an application.
Make an application with the appropriate succession certificate. They have already taken a decision.
Yes, they have already
come to this court. We could not follow. They have already decision so succession certificate produce kale semane joumane thile apun apply hi karna di succession
apply kar
premature writ this writ petition has been filed by the petitioners Duryodhan Sahoo and Saroja Sahoo with a prayer for a direction to the opposite party number 3 and 4 to read the amount which has already been sanctioned. Sanction has been made in the name of your father, late Gopal Sahoo. Stop. It is the case of the petitioners that the homestead land
the death of the land
the homestead land bearing khata number 56, plot number 564, area Ekorsun 150 decimal, which ଆପଣ ବାପା ନାଁ ହେଲା ଗୋପାଳ ସାହୁ ସେଟା ବାପା ନାଁରେ ଥିଲା
ସେଟା ଜେଜେଙ୍କ ନାଁରେ ଥିଲା
ଆଚ୍ଛା
ଗୋପାଳ ସାହୁ has already received the compensation amount.
Was acquired and where have you stated that compensation amount has been paid to Gopal Sahoo
and he received
that? If he has received the same, how it will be again paid to you?
No, that is the PDF amount.
The rehabilitation. So court election Gopal Sahoo payment receive kalani.
Paragraph 4. Compensation page 4. Compensation amount against the aforesaid land has already been paid to the
PDF. Yes, Moujaata leki jantu. Tilei Posi has been acquired by the Mahanadi Coalfields Limited for the purpose of MCL project Bharatpur area, and the compensation amount has already been paid to the father of the petitioner, late Gopal Sahoo. So far as the other benefits,
PDF
benefits, as per the RR policy, it has been decided in the 14th Rehabilitation and Periphery Development Advisory Committee meeting, bracket like them, the RPDAC, of Mahanadi Coalfield Limited, dated 23/2/2025, under Annexure 5.
Issue number 6 at page 24.
Under issue number 6, that is PDA benefits to the heirs of the deceased PDA, that it has been agreed to provide RR benefits of a deceased PDA to his or her successor according to Hindu Succession Act 1956, regardless of whether deceased PDF has moved or not. And no eligible PDF heirs should be deprived of what has already been accrued to their parents. Stop. When we put a pertinent question to the learned counsel for the petitioners as to whether the petitioners have submitted the appropriate application with the succession certificate before the concerned authority to receive benefits, the answer was in negative. The land counsel for the petitioner submit that the petitioners have not yet applied for the succession certificate. Therefore, we are of the view that in view of the decision taken in the meeting dated 23/4/2025, no fault can be found with the authorities in not disbursing such benefits. Stop. Needless to say that if the petitioners file appropriate application with relevant documents before the concerned authorities, same shall be considered in accordance with law. Writ petition is disposed of. Yes.
Item 28.
Set at 23 for set at 23
2.
2.
23/2/2025. For that, yes.
Item 28.
Annexure 1 is the compromise decree by which the petitioner has got the land. Now, my lord, the All India Corporation is constructing a road over that land without any notification for acquisition or without paying any compensation. I have also made a representation to the authorities, that is the opposite party number 2. Annexure 4 is that representation in the June 2024. When we came to know that they are going to take that, they are going to make a road over that land.
No, notification ଆସିବ ନା, notification ଆସିବ ତା ଦେହରେ acquisition, ତାପରେ plot number indicate ହବ,
ସେଟା କିଛି
କରିନାହାନ୍ତି, ଆପଣ କଣ କରିଦେବେ ସେମିତି?
construction ଆରମ୍ଭ କରିଦେଲେ. They have already started the construction. Since without paying the compensation, they are going to construct the road over the land.
ଆପଣଙ୍କର ଜମି ସେମାନେ ଉପରେ ସେ construction ହବ ବୋଲି କି ନାହିଁ, କିଛି ନାହିଁ material, ଆମେ କେମିତି ଆପଣଙ୍କୁ କହିବୁ ଆପଣ? So there must be something on record that your land is going to be utilized for the purpose of that road.
Your lordship may issue notice so that after getting notice, then come that let them say that they are not.
notice ଟା issue କରିବ, ଆପଣ କିଛି prima facie ଦେଖାନ୍ତୁ ଯେ ଏଇ ଯୋଉ ଆପଣଙ୍କର ଜମି ୟୁଟିଲାଇଜ ହବାକୁ ଯାଉଛି ସେ ପ୍ରୋଜେକ୍ଟ ରେ, ଏବଂ ଆପଣଙ୍କୁ କମ୍ପେନସେସନ ନ ଦେଇକି ସେମାନେ କନଷ୍ଟ୍ରକ୍ସନ କରିବାକୁ ଚାହୁଁଛନ୍ତି, ଏମିତି ତ କିଛି ନାହିଁ।
କେବଳ annexure 4
representation ଦେଇଦେଲେ,
when I found that they are
तापर सेठु आसिक सेमाने मन करंतु कहिबे रिप्रेजेंटेशन आमे कहिबु से आसी कहबु कि आज्ञा से जमी हमर नबार नाही कि ताको ऊपर कंपेंसेशन दबार नाही से जमी की यूटिलाइज करिवार नाही तापर कोन होमो इशू नोटिस टा केमती कर दबु गोटे प्राइम फेसी मटेरियल थिले तो करिवु पर को बेसिस रे नोटिस इशू करिवु they may ask also there is no upon representation dispose of karibu. This is a dangerous thing. Jahana is a good representation.
They have already started construction. Lordship may not by commission that
construction nahi thi construction question hoji that whether your land is likely to be utilized in that construction or not. Certainly, if it will be utilized for the road construction, and then you are entitled to for compensation. But nothing is there before us. Normal process जोटा को हुए notification हुए acquisition process हुए number गुड़ा को सब indicate करंती plot number ये गुड़ा को तो ये सब जिनसे हला पर they used to send also notice जहाँ नारे से जमी सब उठाए
Lordship call it 2 week 1 week after so that
this writ petition has been filed by the petitioner with such answers. Land counsel for the petitioner submitted that a representation has been filed by the petitioner before the project manager, Oil India Limited, Mahanadi Basin, opposite party number 2 for payment of compensation. However, we find that there is no material before us that the land of the petitioner is likely to be utilized in the alleged road construction work, which is stated to have been carried out by the Oil India Limited. Oil India Limited. At this stage, land counsel for the petitioner seeks 2 weeks time to obtain in the matter, put up this matter on recommencing from 5th of May 2025. Yes.
Item 29.
May I please, Your Lord, this petition is a valid purchaser of a flat as per Annex 1, followed by possession of lordship since 2018 lordship. And now when the petitioner is enjoying the flats lordship, suddenly he acquired knowledge that the private opinion of 4 and 5.
No, you are praying to quash a particular order.
That I'm coming. That order is I just factual background. Then the 4 and 5 year lordship, they started litigation before the Orera lordship. They are in the appellate authority. In the appeal lordship, when the appeal of the so far the developer is concerned dismissed, then suddenly I found that private opinion 5 started lottering in front of my house. There I collected information. There is a litigation between them, and there the opinion number 5 is claiming that she has been purchased the flat prior to me lordship. Then accordingly, I verified for the appeal has been dismissed. The appeal has been dismissed. So
please be clear. You are challenging
the order of the
Annexure 2.
Yes, there I am not a party lords.
Annexure 2 is the order dated 14/8/2024.
Yes, my lord.
Passed by the appellate tribunal, right?
Yes, my lord.
Okay, and it seems that appeal was filed by one Ananda Construction and Consultation against one Jyotsna Rani Pradhan.
Yes, my lord.
Right?
Yes,
and that appeal was dismissed because of non-deposit of the statutory amount,
yes,
right? Who are you?
I am your lordship, same flat, the flat they are lordship claiming that that flat he has been purchased prior to me, lordship. Then she started case against the developer. Now, your lordship, I purchased the same flat, I am in possession of lordship.
You are declaring your right over
the instance of the petitioner.
You are not a party to a particular order, and you will challenge that order.
So where I have to go, your lordship?
No, even if we reject it or we allow it, where you will go?
Then I am coming, your lordship. Section 58 of
No,
the
no, no, no,
Act,
please,
Your
please.
Lordship, Section 50 of the Act said there is any order passed by the APD is appellate to the High Court, Your Lordship.
No, are you a party to that?
Yes, sir.
Are you a party to it?
There is not necessarily language like this.
So anybody can come in appeal.
Any person agree. The language
Are you a party before the rest?
No, I have not been made a party, Your Lordship.
You will be a party there.
The appeal is not there, Your Lordship. The appeal has been dismissed.
Yes.
If for the adjudicating
The appeal is not there, Your Lordship.
he can file.
Only, Your Lordship, the
You go to RERA.
Yes, Lord. Then I am submitting, Your Lordship. Now in the meanwhile, file an appeal before the appellate authority, Your Lordship, against the original order, Your Lordship, because the section
already filed.
Yes, the
what is number appeal number?
7/1/2025, Lordship. 7/1 of 2025.
Just a number takun. OREAT appeal number
7/1/2025.
71
of 2025. That is in file 7/4/2025.
7/4/2025.
I pray that may be targeted, Lordship. So the or else, Lordship, by virtue of the appeal order.
Target. This
or already disposal Lordship, because by virtue of the order they may be taken over possession. I may be
has
kicked out,
been
Lordship.
filed by the challenging
The original order
stated
passed by the NHAI, Lordship.
14/8/2024.
No, they thought I been challenged before the authority.
So, Council, this is your prayer. We are
Yes,
reading
yes.
from the prayer to pass the order dated 14/8/2024, passed by OREAT, Bhubaneswar in OREAT, appeal number 29T of 2020. With a further prayer to permit the petitioner to participate in the said appeal by filing appropriate application. On perusal of the impugned order passed by the appellate tribunal under Annexure 2, it appears that the petitioner was not a party in the said proceeding, and the case was filed, the appeal was filed by Messrs. Ananda Construction and Consultation Private Limited, another, against one Srimati Jyotsna Rani Pradhan. Therefore, at the instance of a third party like the petitioner, we are not inclined to set aside the order dated 14/8/2024. At this stage, the learned counsel for the petitioner submits that he has filed another appeal, an appeal before the Orissa Real Estate Appellate Tribunal, which has been registered as OREAT appeal number 71 of 2025, 7/4/2025. Stop. It is up to the petitioner to pursue the said appeal in accordance with law.
But in this case, I am appealing for the opposite part number 2 and 3.
The Mr. Private opposite partner?
Yes, RERA.
Acha, RERA. The Mr. Nayak Learned Counsel appears for Swansea to opposite party number 2. Yes, next.
Obligation.
Item
It will
30.
say to be early disposal of the appeal, Lordship.
There is no such prayer, Mr. Item number 30.
May please. Here the notice dated 5/4/2025, demolition notice, eviction from demolition notice is under challenge, Your Lordship.
5
notice. Annexure 11, 5/4/2025, the issue is left, and it was directed that the date of eviction or demolition is 11/4/2025. Mane aji hi today. It arises out of a land acquisition matter, Your Lordship. In the land acquisition matter, the notification was there. I was positioned in the suit land, case land. Compensation was assessed. Compensation was given to me. I have received 26 lakhs compensation. Your Lordship, thereafter, in the rehabilitation resettlement policy, which is dealt in section 31. Here the notice, if Your Lordship kindly looks at page number 17, annexure 3. There, the 7 lakhs rupees, the Anukampa Muloko Rasi 7 lakhs, Pradhan Numonte Spirikuto Huichi. So it was not issued in my favor. The notice was not issued in my favor. Rather, it was issued in the name of the persons who are not in possession, madam.
Thereafter, I filed the objection before the special LAO, the opposite party number 5, that is the Annex of 4. That I am in the case land, I am possessing the case land, I am going to be displaced, my house is going to be demolished. You please take necessary steps to include our name so that we can get that rehabilitation package. And we are two families. So thereafter, no step was taken. Then I approached the sub-collector, Annex of 5 minor. I filed a representation before the sub-collector. Sub-collector directed the Tahsildar to make an inquiry. That is the page number 20, Annex 6. The inquiry was conducted by the Tahsildar. The RI was directed to visit the spot and submit the report. The report of the RI is page number 22. If you also kind, that is the crux of the matter. May I read that?
22.
Yes, yes. That is the report of the RI.
21.
No, 21 টা হচ্ছে তহসিলদার
21 is RI report.
ତାକୁ ବେସ୍ କରିକିନି 21 ହେଇଥିବ ଆଉ
ହଁ 22 ବେସ୍ କରିକି 21 ହେଇଛି 22 is the RI report ଆଉ 21 ଟା ହଉଛି ତହସିଲଦାର ଲେଖିଛନ୍ତି ସବ୍ କଲେକ୍ଟରକୁ ତ ସେ ଯଦି ବି 21 କୁ ବି ଦେଖିବେ ସେ ଏଥିରେ ଲେଖା ହେଇଛି
କଣ ଲେଖା ହେଇଛି
ମ୍ୟାଡାମ ଦ ସେକେଣ୍ଡ ପାରାଗ୍ରାଫ ମ୍ୟାଡାମ
ପଢନ୍ତୁ
yes sir. Further, the special land acquisition officer Salga Budha Panka, Talcher, Jharpara, 3rd and 4th line project, Venkanal has issued notice dated 5/2/2025 and 11/3/2025 amounting to ₹7 lakhs towards payment of rehabilitation and resettlement of the khata holder of the land, except the name of Sri Pradeep Kumar Naik and the Manorama Naik. We are the petitioners, Pradeep Kumar Naik and Manorama Naik. Our names are excluded. That is the report of the Tahsildar, that is the report of the RI. That report has been for the sub-collector, and the sub-collector communicated the report to the land acquisition officer. Despite that, my lord, Annex 11 was issued. Annex 11 would not have been issued.
You are claiming a share from the compensation amount.
No, Your Honor, I am not claiming the share.
Which has already been determined.
It has been paid to me.
No.
Paid to me.
26 lakhs you have received.
Yes.
This 7 lakh you want to get.
Two packages, my lord.
All right. This is all right.
Yes.
So,
and without giving that package,
all right.
The eviction could not have been issued. You will also kindly look at section 38. 38 of the 2013 Act. It's maybe permitted.
No, it is likely to be paid to, let us say, opposite parties number 6, 7, 8, and 9.
It is directed
right.
to
And you
have been excluded.
You have been excluded. You want that a portion, a party will be
I am the beneficiary.
What is is there no other provision that you are to approach that authority to
get the amount recovered?
Well, what my humble submission is, I will come to that your point. Well, kindly look at section 30. It says that the collector shall be responsible for ensuring that the rehabilitation and resettlement process is complete in all aspects before displacing the affected families. So, before getting that amount, the rehabilitation and resettlement amount, I could not have been evicted, my lord. But the demolition notice, it is at Annex 11 that has been issued, my lord.
The authorities have already paid
the
compensation. That is the wrong statement made in the notice, my lord. We have not received, nor that persons, the opposite party number 6 to 11.
You said that you have already received 26 lakhs.
26 lakhs.
Yes.
That are the two parts, my lord.
This amount you can recover.
No, your worship, that
you cannot recover.
My lord,
an amount which can be recovered or compensated in terms of money can be stayed. Is it your case?
My lord, chapter 4 deals with the compensation. I have no grievance regarding the compensation. Chapter 5 deals with the rehabilitation and resettlement package, my lord.
Yes. And the amount is also settled.
The amount is also settled.
So you know the amount. You are only claiming that you have been excluded, you are to receive.
Apportionment अनुजाई यदि आपण गोटे claim करूछंती, there are other alternative remedy, you avail that.
But section 31 says that each affected family is to get the award, my lord. Here we consist two families, your lordship. Two families. So without giving that package to us, the notice could not have been issued in view of section 38 subsection 2, my lord. That is my case. This is a statutory prohibition, my lord.
Prohibition.
Yes, your lord.
Okay, all right. Super.
Which provision you are pressing?
Right. So first, I am pressing section 31.
Yeah.
May I read me?
Please, please.
Yes. 31 says rehabilitation and resettlement award for affected families by the collector. 1. The collector shall pass rehabilitation and resettlement award for each affected family. In terms of the entitlement provided in second schedule, second subsection 2 says the rehabilitation and resettlement award shall include all the following, namely such and such. Therefore, I am coming to section 38. 38 provides power to take possession of the land to be acquired. Subsection 1 says the collector shall take possession of the land after ensuring that full payment of compensation that I have already received.
Yes, yes.
Compensation as well as rehabilitation and resettlement entitlement that are paid or tendered to the entitled person within a period of 3 months for the compensation and period of 6 months for the monetary part of the rehabilitation and resettlement entitlements listed in second schedule, so and so. Whereas subsection 2, you can also kindly look at subsection 2. It says the collector shall be responsible for ensuring that the rehabilitation and resettlement process is completed in all aspects before displacing the affected families. That means I have to receive the compensation amount, I have to receive the rehabilitation and resettlement amount. Thereafter, my displacement will take place, my lord.
They have already quantified or not? এই କେତେ ଟଙ୍କା ଆଉ ରହିଲା ସେଟାକୁ କ୍ୱାଣ୍ଟିଫାଏ କରିଛନ୍ତି ପରା 7 ଲକ୍ଷ ଟଙ୍କା
7 ଲକ୍ଷ ଟଙ୍କା କରିଛନ୍ତି ସେମାନେ ଯୋଉମାନେ ପଜିସନରେ ନାହାନ୍ତି ତାଙ୍କ ଫେଭରରେ କରିଛନ୍ତି.
What is 64? What is the 64 says?
Reference to the operating man.
Then
so what my submission is, only 5 days time was granted to remove my belongings or else the demolition will take place. That is not a
ultimately demolition habo. Question होती आपण payment ପାଇଁ जो मागुचंती in view of section 64 if you alternative remedy available with you
to approach the collector and make the record.
Yes, that is it.
Make it. I bow down.
The writ petition has been filed by the petitioners Pradeep Kumar Naik and Monorama Naik with a prayer to quash the notice dated 5/4/2025 passed by the Special Land Acquisition Officer Saloga Buddha Pang Talchev Jalpoda opposite party number 5. The London Counsel for the petitioner submitted that the case land relates to khata number 345, plot number 336, Kisam Bharwadi, 9 December. And for acquisition of such land, the petitioners have received a sum of rupees 26 lakhs, including solatium, on 28/3/2023, in lieu of acquisition. And though the authorities have quantified rupees, sera kote 7 lakh ta code lekha ji
7 lakh yo lotchi
Annex 9 page 23.
Annex 9
ha 7 lakh code lekha ji
Page 23, my lord.
23.
Page 23, Annex 9. Notice dated 11.
हाँ 7 lakh
as well as Annex 3 page number 70.
ठीक है
Seat annex.
Quantified rupees 7 lakhs to be paid for rehabilitation and
resettlement
package. But the petitioner has a share in such amount. But
two shares, my lord, two families.
The petitioners have 2 shares in that amount. But no notice has been issued to the petitioner. On the other hand, a demolition notice under Annexure 11 has been issued, wherein it is stated that today, that is on 11/4/2015, the authorities will demolish the structure and acquire the land. Referring to Section 31 of the 2013 Act, the counter the petitioner submits that it provides the collector to pass rehabilitation and resettlement awards for each affected family in terms of entitlements provided in the second schedule. He further placed Section 38 of the 2013 Act, wherein it is stated that the collector shall take possession of the land after ensuring that full payment of compensation as well as rehabilitation and resettlement entitlements are paid or tendered to the entitled persons within a period of 3 months for the compensation and period of 6 months for the monetary part of rehabilitation and resettlement entitlements listed in the second schedule. And subsection 2 of Section 38 states that the collector shall be responsible for ensuring that rehabilitation and resettlement process is completed in all respect before displacing the affected families. It is the contention of the Land Council for the petitioners that when the petitioners have been paid a sum of rupees 26 lakhs on payment or 28/3/2023 for the acquisition of the land for the self-same land, the rehabilitation and resettlement entitlement should not have been deprived by the authorities. And the action of the authorities is foresee illegal. Section 64 of the 2013 Act deals with reference to the authority, and it states as follows. Quote kar devi. In view of such provision, since alternative remedy for availing a share in the quantified amount of rupees 7 lakhs as per annexure, annexure 9, na?
3 and 9, both.
Annexure 3 and 9 are available with the petitioner. It is this petition is disposed of giving liberty to the petitioner avails such. Accordingly, the writ petition is disposed of. Yes, next.
Item 31.
It's 17. The impugn letter page 17. This is in the form of a Stoker's notice. But you will see the penultimate paragraph of this notice. That's rather the clinching point is here. Before I take your lordship to the facts, but you may see the clinching point is penultimate paragraph. You have premeditated, you have determined to resume it,
then calling upon me to show cause and submit documents on the ground given your notice.
Annexure 19.
Not Annexure 1.
Oh, Annexure 1. Super notice. Okay.
Kindly see the penultimate paragraph. Last but one.
Who is appearing for Cutter?
But I'll have to take notice.
On behalf of Sanjeev Sai, appearing for CD.
Government authority by he appears.
Sanjeev Sai.
Dayanand Mahapatra.
Also, we are also appearing for CD.
No,
Lord, your Lordship, now kindly see page 23. Lord, previously your Lordship has the occasion to visit these documents. Your Lordship has seen these documents in an earlier matter, which is pending your Lordship's order. I'll show, my Lord. Page 23, my Lordship.
No, we disposed of a matter that is on 13/3/2025.
That is for the same land. The straightway gave me a notice of disposition and eviction.
What order was passed there?
That was passed. That eviction notice, page 45.
Page 45.
No, page 45 is your Lordship's order. Acha, page 45
there the notice has been issued.
1 second.
In that case, the notice has been issued.
Earlier matter. That has been passed. Page 45, Lordship may kindly see, on the ground of natural justice, not a notice. Straightway order of disposition was passed. That was passed on consent of the parties. Page 45. Then thereafter, we have approached your Lordship for execution of lease deed. Page 47, your Lordship may kindly see. Your Lordship's order. That despite the fact that you allocate on long-term lease basis, you are not executing a lease deed. I filed a writ petition. Your Lordship has been pleased to issue notice there.
Yes.
Page 47.
Yes.
Now, after receiving notice, they have issued this order.
Which order?
Lord, the Annexure 1.
Annexure 1.
Annexure 1 is a notice to you.
Right, Lord. After receiving notice from
to appear on 16 and submit your document.
Before that, they have already decided to resume it.
Where is that?
That's what I was trying to show.
You are going by the you are showing the intention of the party of the record.
They have to resume it.
Where is that?
That is there. Annexure 1, page 17, my Lord's kindly.
Annexure 1.
17. Annexure 1.
Yes. Who could put on the TA?
Sir, Paduchi, without prejudice to any contentions concerning, what it means? Without prejudice to any contentions concerning lapses in the execution of the license or lease agreement, it is to appraise you that authority requires resume the plot so as to best utilize its largest, putting it through public auction.
All right, that is one part, but it is on the basis of a direction issued by this court in 7473 of 2025.
Right.
They are bound to issue notice
of course,
to give you an opportunity of being heard.
Of course.
Basing on that, this notice has been issued, directing you to produce the document.
Yes.
And a date has been fixed.
Right, man.
So you fix it.
If it would have been a simple notice for that, I would have considered to that. Today, I am supported by 5 judgments.
So now that whether you will
cannot give such a notice, it's a post-decisional hearing.
Yes.
It's a post-decisional hearing, not permissible in the IF law. Violates principles of natural justice. You cannot. You having taken a decision to resume it, there is no point in giving me opportunity of hearing. It's an empty formality now. You have 5 judgments. 5 judgments on the point. And more particularly, after receiving notice from my lords on the question of execution of lease. That's the point. The lordship like to see the judgment.
Yes. We'll give it to Eviction. The order was passed in WPC number 74. Pass
page 47. There are 2 orders. One is at page 45, the other is page 47.
Writ petition has been filed. by the petitioners quashing the impugned letter dated 2/4/2025 issued by opposite party number 2, Vice Chairman CDA under Annexure 1. The Mr. Rothal and Senior Advocate appearing for the petitioner submitted that the when an order was dated 25/2/2025 was issued by the Vice Chairman CDA Cutter, opposite party number 2, to hand over the property present and purchased by the petitioners association, along with removal of any undefined assets of the establishment within 2 weeks, failing which the authority shall take action as deemed suitable under the provisions of ODA Act to take over the said property. The petitioners approach this court in WPC number 7437 of 2025, challenging the order dated 25/2/2025, and a London single judge bench of this court, by order dated 13/3/2025, has been pleased to quash the said order and directed the authorities to follow the principle of natural justice by giving opportunity of hearing to the petitioners. The petitioners thereafter filed another writ petition by WPC number 729 of 2025, wherein a prayer was made for a direction to the Cuttack Development Authority to execute formal deed of long-term lease in favor of the petitioners association within a stipulated time. As the petitioner has been continuing after establishing the petrol pump on the allotted land, and the CDA has given its expressed consent in the shape of NOC and insisted upon execution of a formal deed of lease. In the said writ petition, notice was issued to the opposite party, and by order dated 24/3/2025. And after receipt of such notice, the later dated Annexure 1 was issued on 2/4/2025 to the petitioners association. The Land Council submits that on a plain reading of the letter under Annexure 1, it would reveal that the authorities have already decided to resume the plot, and thereafter they have issued the so-called notice under Annexure 1. It is further argued that in view of the ratio decided in the case of Swan Jurisdiction Godale, the Annexure 1 is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission, and requisites for issuance of notice be filed by next week. This matter is to be listed along with WPC number 78 29 of 25. Counter affidavit, if any, be filed in the meantime. Right? Yes.
But I have to repeat that. Can we see, Lord, they have passed an order and proceed to take decisions on 16.
No coercive action shall be taken on the basis of annexure 1. That is the IN number 1. So this is an application.
Great. Copy of writ application be served on us.
But only
no, you see that there is a panel of counsel. Mr. Dayanand Mahapatra is there, Mr. Sanjeev Swami is there. So they may interest either to Mahapatra or they may interest you. Why we will say that it is to be supplied to you? If you would have been the only counsel, matter would have been different. Right?
Yes,
so now, Mr. Please file those decisions, sir.
We have
and shall be taken up. Needless to say that the petitioner shall participate in the proceeding.
16 you participate, but no coercive action will be.
Final decision, of course. Yes.
No final decision shall be taken.
Yes,
that is
final
obvious.
decision shall be taken. And no coercive action also on the basis of energy. Decision relevant paragraph would have highlighted. Paragraph would have highlighted. So,
one just small fact.
Yes.
But my participation should be without prejudice. That's my kindly indicate. Otherwise, we'll not once
Without prejudice in this
without prejudice to my contentions here before my.
Obviously, we are passing this order here only.
Kindly protected to that extent. They say I have participated, I'll be punished.
Without prejudice to your right in the present treatment.
But I just
participation
of small without
great good.
My lord, item number 32. My lord, I have filed a appeal. Prior to it, jail criminal appeal was filed in.
Launch for a court, nahi?
Item number 12 the representation of court and Bappa देखिए. Representation मतलब annexure 4 है तो Bappa देखिए.
कौन ये order है ग्रानी कौन है यार?
हमें तो
appears to the urgent repeated call. Yes.
Item 32.
32 not see. I have filed CRL 380 by 25. The information given by the appellant was completely wrong one. What I gathered today morning. Because he has earlier preferred a jail criminal appeal in the year 2013. It is a judgment of 2013. So my appeal may be.
That is also sub judice. It has not been.
Yes. He has not.
Mr. Arijit Mishra, let me second that. Let's see the number 3. That since the appellant is already filed JCRL number 50 of 2013 challenging the judgment and order dated 30th of July 2013 passed by the London Session Judge Korapur Jaipur in criminal trial number 63 of 2012, which is sub judice he does not want to press this appeal. Accordingly, the CRL number 380 of 2015 is disposed of as
25.
2025, not question. Yeah.
For the council, that's what is into
The first item, my lord.
And going by the council to legal at prisoner's petition is that Advocate Anand may kindly be seen. Paperbook song and so on. Where is Rajalakshmi Das? Divyasri Rai ଅଛନ୍ତି?
ମୁଁ ଦେଖୁଥିଲି ଆଗେ ଦିବ୍ୟଶ୍ରୀ ରାୟ ଏନଗେଜ ହେଇଥିଲେ ଟ୍ରୁ ଲିଗାଲିଟି ତାପରେ ପ୍ରିଜନର ପିଟିସନ ଆସିକି ରାଜଲକ୍ଷ୍ମୀ ଦାସ ଏନଗେଜ ହେଇଥିଲେ
ଦି ଜଣ ଯାକ କେହି ନାହାନ୍ତି let Mr. Arijit Mishra with the council Amai Security engaged for the though the prisoner's petition has been though the prisoner's petition at flag Y has been received praying for engagement of Rajalakshmi Das but and her name has been reflected in the cause list. She is not present. Even the earlier counsel, Ms. Divyasri Roy, whose name is also reflected in the cause list, is not present. Therefore, Mr. Arijit Mishra is engaged as the amicus curiae for the appellant. His name shall be reflected in the cause list in place of Divyasri Roy and Rajalakshmi Das. Okay. So, Mr. Mishra, you received the paperwork. Let a copy of the paperwork be supplied to Mr. Mishra. आज ये अच्छे से दे दियो साइड में, है ना? Please दे दो. Next.
Proceeding keep it to we commence 20th.
Matter will be hearing will be commencing from 21st June, April 2025. है ना? Under the heading of hearing. Here.
Item 33.
Please, on behalf of Mr. Ramdas Acharya, I may be permitted to. What has happened was, since this was a jail criminal appeal, the court has earlier appointed a counsel
The proof can be ready. You have to receive the paperwork also. And paper also can take on next week. Ready for bail.
Hearing next week cannot be taken up a week after.
Order also. Bail is pending also.
Oh. All right. The learned counsel for the Mr. Das, learned counsel for the appellant, submits that he may be supplied with a copy of the paper book, and the matter may be taken off to be put of this matter for orders in the week commencing from 21st April 2025 with CRLA number P87 of 2019. A copy of the paper book be supplied to Mr. Das. अच्छी जल्दी दे दियो तो during course of the day, है ना? नहीं जानते रिसीव करेंगे। ये order sheet sign करेंगे नो तो दिन। कोई शक हुए जब कुछ next.
Item 35.
Yes. Next week. This party learned counsel for the apparent 6 for an adjournment. There are still. Put up this matter in the week commencing from 21/4/2025. Yes.
Item 36.
At least 6 Amitabh Tripathi.
On behalf of Mr. Amitabh Tripathi, madam. And paper one set of paper book, madam.
Okay. The learned counsel for the appellant so appearing on behalf of Mr. Amitabh Tripathi submits that a copy of the paper book may be supplied to him and the matter may be taken up a week after. Put of this matter in the week commencing from 21st April 2025. Copy of the paper. आज ही रिसीव कर दियो है ना सिग्नेचर कर देवे ऑन बिहाफ ऑफ मिस्टर अमिताभ त्रिपाठी लिख दो
यस
Item 37.
यार पावर નથી हो तो ऑन बिहाफ ऑफ लिख दो
Item 37.
It only 37 से शताब्दी को दिया ही से तक चेंज करने पड़े हमें 10 का ये 200 कमाई तब तक आपने चेंज कर दिया मुझे बराबर है ना is also not there.
चलो 2023 होगा
पेपर बुक इज रेडी पेपर बुक इज रेडी
No. Shatabdi Samuntraya is not having the practice of 10 years, so therefore she could not have been appointed as an amicus curiae in a 302 case. So that is the since Mr. Miss Shatabdi Samuntraya, who was engaged as the amicus curiae as per order dated 5/9/2023, is not present. It appears that is feel that she is not having the practice of 10 years. In view of the decision, so on so sad yes, next. Out the name of Shatabdi Samuntraya shall not be reflected in the clause. Yes.
Item 38.
It will make us very GST. And never stop. Come here.
No.
Talaknama has been filed.
I number 2225 2720.
You see, the prisoner's petition has come in the name of Vijay Lakshmi Tripathi. She is now in the government panel. So, unless she specifically says yes to your engagement, she has no objection. In a jail criminal appeal, it would not be proper. So why don't you ask her to send another petition?
Original petition bill Tripathi filed 30/10/2024.
ବୁଝିପାରୁନାହାନ୍ତି ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀଙ୍କୁ ସିଏ ରିକ୍ୱେଷ୍ଟ କରିଛନ୍ତି ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ ଏବଂ ଆପଣଙ୍କ ନାଁ ସହିତ ପିଟିସନ ଫାଇଲ ହେଇଛି ବିଜୟଲକ୍ଷ୍ମୀ ତ୍ରିପାଠୀ ଯଦି ବର୍ତ୍ତମାନ ଷ୍ଟେଟ ପ୍ୟାନେଲରେ ନଥାନ୍ତେ ତାହେଲେ କିଛି ଅସୁବିଧା ହେଇନଥାନ୍ତା ଯେହେତୁ ସେ ଷ୍ଟେଟ ପ୍ୟାନେଲକୁ ପଳେଇଲେଣି ତେଣୁ something has to come from the either you do it or we will engage somebody else.
Instruction of the
But you also take instruction that if she is in writing, here is the prisoner's petition at flag A, which is dated 22/8/2024, in which request has been made to engage Ms. Vijayalakshmi Tripathi as his counsel. Prisoner's petition of the appellant. Though Ms. Tripathi, along with her associates, have filed wakalatnama. However, it appears that now Ms. Vijayalakshmi Tripathi is in the state panel. Therefore, the Land Council for the state obtained instruction through the concerned jail superintendent as to whom the appellant wants to engage as his counsel. Free copy of the order be handed over to the Land Council for the state. Matter will be listed in the week commencing from 21st of April 2025. Yes.
My lord, my name may kindly be deleted. Ananya Mishra.
The name of Ananya Mishra and Miss Vijayalakshmi Tripathi be deleted from the cause list. Yes. I would have दरकार अच्छा 5 तारीख को 5/5/2025
पेपर बुक
अच्छा Miss Ananya Mishra returned the paper book which she has accepted. The same may be kept on record. Yes, next.
Item 39.
Only the presentation is there. I have appeared. I was permitted to receive the paper.
अच्छा वकालतनामा फाइल कर दीजिए एल भुइया सरोज कुमार को आम एंगेज करते कोर्ट हाँ I order dated 12/11. लिखो prisoner's petition at flag A has been received for engagement of Mr. L. Bhuiya in place of Mr. S.K. Hon'Ble. Mr. Bhuiya is present in court. He has already filed wakalatnama, which is accepted. The name of Mr. S.K. Hon'Ble, Saroj Kumar Hon'Ble, shall not be reflected in his list. Mr. Bhuiya, a request for supply of a paper book. Let a copy of the paper book be supplied to him during the course of the day. Aji nahi jante. Next.
Item 40.
Delay filing the writ of
How much delay?
96 days.
Notice has been issued.
During COVID period.
No, notice has been issued on limitation.
Yes, I have appeared on behalf of the.
How many writ appeal kind? Writ appeal does it know? Writ appeal. So there is only one respondent.
Yes.
You have already appeared.
I am the petitioner in the writ application. Against the order, the appeal has been filed.
So, any objection or you will condone the delay?
No, it can be disposed of.
No, first that delay condonation application is to be
delay, the reasoning has been assigned is about, yeah, your lordship may,
all right. That
without his consent.
IA number 318 of 2020. This is an application for condonation of delay. The stamp reporter has mentioned that there is a delay of 96 days in filing this writ appeal. Mr. Shamant and counsel for the respondent, who has not filed any objection to the delay condonation petition, but objected to the prayer for condonation of delay.
No objection we have filed.
Filed for them?
Yes. Mr. Mahanta, not
Mahant, I'm sorry. Where is that objection?
I filed the objection.
Objection.
I have, yes.
I have also not received the objection.
Arising out of Dublin Enforcement. This is dated. It is not there.
Objection nahi, mane jodi file korchandi kebe kuhuntu ame puni aku record ko aniya padibo karana eti kichi nahi objection.
You have filed caveat.
Caveat is
that's there. No objection is not there.
And if the delay is during COVID,
All right, we are not.
Sabu hela siye कहलेनी delay condon hobo auri puni कहउछन argument करउछन je Mr.
In the affidavit that objection
Mr. Mahanta,
on the merit.
If we write that no objection is filed, your client may feel something. That is why telling you.
Yes.
So let it come on Monday. Next week कौन असुविधा है जी? ते को कहबे ना जे हम अपन केमती delay हम कहइथिली instruction देले.
No, this has been done in this affidavit that has been filed.
अपन जे कहबे file करछन्ती बेली will place the same on record and take up this matter next week. Kintu jadi if you will manage with the client, we can condone the delay. There is no problem.
We can condone it.
All right. Take down. No objection has been filed to the however the Mr. Mahanta opposed the prayer for condonation of delay. Considering the submission made by the learned counsel for the parties, the governments taken in the delay condonation application, we are inclined to condone the delay. Accordingly, delay is condoned. I is disposed of. Writ appeal be taken up in the week commencing from 21st of April 2025 for admission.
I have one submission.
Yeah.
The judgment is of 2019. The petitioner, as per the judgment, the petitioner is entitled to the promotion from the post.
No, you see,
and just 1 minute, my lord.
The next week list has already been finalized, so we can place only on 21st.
He is retiring in month of May, my lord. The promotion will not be getting any benefit.
This is to come up under the heading of admission. So, I'm dispose of
can also be disposed of here because
next
I think my learned friend will learn.
Let it come on that day. In the meantime,
21st.
Yeah, man, shut up. Thank you.